online and throughout Parliament buildings. Members, as always, you're entitled to use your mobile phones as long as they're in airplane mode and all devices are muted. So you can also connect to Assembly Wi-Fi using the usual parameters. So not permitted to take photographs or record the meeting. We have no apologies indicated thus far, but we do have some members joining us remotely. We're awaiting Deirdre, I believe. But
she should be in person, I think.
Okay, great. So, declaration of interests, first item. Members, at the beginning of all meetings, you're required to declare any pertinent interests. Does anybody have an interest they wish to declare? No? Okay.
Thank you.
Agenda item 3, chairperson's business. 3.1 relates to the expert panel on the review of public procurement governance arrangements. That is at page 6 of the meeting pack. So members, you will see that you may remember us being updated on the creation of the expert panel. I have been asked to meet with the expert panel, which will be reviewing, along with the Deputy Chair, which will be reviewing procurement governance structures in response to recommendations in the recent PAC report. Members are content. We will.
Deputy Chair, you content to be?
They wish to
make yourself
to
available
go to the procurement governance.
Yes, thanks, Chair. But just to declare that I also sit on the PAC, so happy to either be involved, but happy that you do. It might be a conflict.
I was just checking. Yeah, I was just checking that. I mean, you might be more abreast of the actual report.
Yeah.
But anyway, okay, right. Now, agenda item 3.2 is at page 8 of the meeting pack, and that is correspondence from Chartered Accountants Ireland. They are undertaking a renewed campaign to secure a reduction in corporation tax. A briefing for the committee has been offered. So, members, just on this, on the corporation tax point, I mean, I think it's worth us examining the contents of this in the context of future meetings that we will have on fiscal devolution and even revenue raising, which is obviously a related subject. They cite in their report the report of the Fiscal Commission, which came out a number of years ago. They also say that it has. They also say that it would be that you could have an interest-free loan from the Treasury to cover the fiscal consequences. Personally, I'm slightly intrigued by the latter argument. I'm not sure how realistic that is, to be absolutely honest, but it's certainly a policy thing that's been brought before us, and so I would suggest to members that at this stage we leave this until we are having a discussion on more fiscal devolution, but I'll bring in members to give their views. Deputy Chair first.
Yeah, thank you, Chair. And whenever this has been relaunched and they're reaching out to us and the Economy Committee, I would suggest that it might be good to have a joint informal briefing with the Economy Committee just to see what's coming with the campaign. It would be good that clearly the campaign is going ahead, so it would be really good if both committees heard it directly. So are you suggesting setting up basically a briefing committee so committee members could attend informally if they wish? Yeah, well, as they're happy to take the advice of the clerk, but just when I've seen it coming in, it's coming to both committees there.
What might work well with something like that, because they were meeting on Wednesday morning and we're the Wednesday afternoon, is if we did something in between, maybe some kind of informal lunch or something like that. Yeah, like or we could bring them in to talk.
Yeah, Chair, I would propose that something like that would be useful.
I'm perfectly happy with that. I mean, I would just say to people, if maybe the people are unable to attend, but obviously it's not going to be a 3-line whip. But if people wish to join, that's reasonable. Steve Aiken.
Yeah, thanks, Chair. Just first of all, declaration of interest. I'm meeting with CIA. I think it's either tomorrow or on Friday for a meeting to specifically talk about that. So that's a declaration of interest. And secondly, I concur what the Deputy Chair says. Maybe a joint meeting might be useful.
Okay. I think it would be probably more an informal briefing than a meeting. It may be that at a later stage people want to have a more detailed meeting and challenge or test or investigate some of the arguments, but bring in Scherie now. Jerry Carroll.
Thanks, Chair. I mean, I think it's a bit strange, given the time that we're having like record profits being made by corporations, that this, quite discredited argument is doing the rounds again. But obviously any organisation are entitled to contact the committee and hear their views, which they are entitled to. My only suggestion is that I think there needs to be a bit of balance, and like I said, the view of lowering corporation tax is quite discredited. So I think for balance, there should be at least one other organisation either offer a briefing to the committees alongside or shortly after the chartered accountancies. So you've got the Nevin Institute, the trade unions are opposed to the corporation tax being cut. So either one of those or another organisation, just so not just for political balance, but to make sure all members have the full arguments for and against.
Yeah, I don't disagree. What I don't want to do is get into a kind of shadow briefing thing where we're organising kind of shadow evidence sessions. This would not be an evidence session because it's not formally before the committee yet, and I don't think we should have a formal evidence session. So I take your point, Scherie. The only thing I don't want to do is clog up members' time with kind of invites to briefings. This isn't a three-line whip. To be absolutely clear, this meeting is not being set up with members compelled or expected to attend. It's if they wish to. But what I would suggest in answer to your question is, if we forward this to, you mentioned the Nevin Institute as one example. I don't know if there are any others who have given thought. I mean, what the current position is with the corporation tax reduction is, so far as I'm aware, obviously, this provision has never been. It has never been enacted, or it hasn't been commenced, this power in the 2015 law. I'm not aware that the Minister has any plans to commence it or bring it before the Executive to commence it. So it's not a live proposal as yet. Now, people will have views on either way, but at this stage, and until we as a committee are formally examining fiscal devolution, we have enough on our plate in terms of evidence sessions. But I think an informal session, should members wish to attend, is totally reasonable. But I'll just suggest we will write on, further to your request, Scherie, to ask for the views of Nevin
and the kick to Northern Committee of the Irish Congress.
Sure.
Trade Unions.
I mean, they can give us their view, and if people want to send on top of that makes complete sense. I mean, I don't think a meeting's a bad idea. It's purely that I don't want to clog people's diaries up. Scherie, go on ahead.
No, sure, that's fair enough. But I just, there could be a danger of people getting the perception that, that it might be the view of the committee if we're, giving credence to the one sort of viewpoint. And I'm not opposed to even attend that meeting if I can attend, even though I disagree with the proposal. So I think maybe contacting those organisations and keeping it open for them to kind of offer a briefing as well down the line would be, I think, just in the interest of balance. So I'm happy with that.
Go ahead, Deirdre. Pardon me, Deputy Chair.
Yeah, thank you, Chair. And I was just thinking in terms of the efficiency, obviously Steve's arranged a meeting and we'll all individually end up having this meeting. So I was just thinking in terms of if all members of both committees were going to be meeting to talk about this anyway, it might have been an idea.
So I think we're agreed then there will be a suggestion of an informal briefing, which is not a formal committee briefing, and the committee and this organisation should not be under the belief that they are getting a formal committee meeting, because we are taking evidence on this. If we are at some point later when it comes to fiscal devolution, if there's a more formal proposal on the table, we'll happily take evidence from them. At that point, we would also want to take evidence from people who take a different view, including in opposition to this particular measure, which is not a live policy proposal. Gerry's point is fair enough. If we are asking, if we're offering them even to facilitate some kind of informal meeting, we should also write to others who have a counter view on the advisability of a corporation tax cut. So in the first instance, we'll write to the Nevin Institute and Nicol, who kind of overlap a bit anyway. Okay, we'll do that, and if people are happy enough with those actions. Now, we will then move on to, and I should just say that I do expect we will have the opportunity to ask the Minister about his plans on fiscal devolution at some point before Christmas, whenever 10th December. It is worth saying there's lots of areas where we don't have clarity from the Minister of the Department. On this one, we do have a degree of clarity that he isn't planning on doing it before the end of the mandate. So it's a discussion point for probably after that. Right, now, members, 3.3 is from the House of Commons Library, and it relates to public finances. It's a document which basically sets out how bad the UK public finances are and how public sector net borrowing, i.e. the deficit, is going up. It's really for people's interest ahead of the budget at the end of the month, unless anybody wishes to say anything about it. 3.4 is is a petition which was brought before the Assembly by one of our members. It's on page 22. The Speaker has formally written to us to inform us that the petition on scrapping the rates exemption, i.e. The industrial derating provision, was laid by Scherie MLA of this parish. The Finance Minister has also been informed, so I don't know if anybody wishes to discuss that. Scherie, you may want to discuss it. Anybody else is more than welcome to say anything about it if they wish.
Oh, sure, I'm content, thanks.
Sure, okay.
Thank you.
Grant. Next item is 3.5, which is the ministerial oral briefing on the 10th of December. So, members, the DALO has asked the committee for a list of key items that members wish to discuss with the Finance Minister at his briefing on the 10th of December. So, members, you don't have to now, and I'm not going to try and detain us all afternoon for people to come up with every possible thing they might want to raise with the Minister. So, either shout now, i.e. right now, or email it separately to the clerk.
Chair, we have a list anyway. And what we might do is probably tomorrow circulate it to members and see if members want to add anything. Obviously, fiscal devolution that you've just highlighted is one of the items. Budget, obviously, the new multi-year budget coming forward. December monitoring as well.
I should just say exactly December one. I should just say that, and fiscal devolution I'm sure will come up too, given our previous conversation. I should also just say, as we discovered in the past, I think members in this committee now are well enough able to differentiate, but there will always be the desire to drag finance into discussions about whether X area is funded enough. I'm not sure that's necessarily, some of that stuff will come up, I'm sure, in the briefing, but I'm not sure that is the best use of our time with the Minister, or indeed the best use of the Minister's time. Not that I'll stop people asking questions, but just to say, a conversation about whether overall, about specific areas in terms of spending decisions that are largely made in other departments is always the right way for us to use our time. But that's a question for members. Just want to make the point. Now, one more item of chairperson's business for me, which relates to something which has obviously been in the news over the last couple of weeks, and that is the Education Minister's visit to the Middle East, and specifically to Israel and the occupied territories. Members, obviously, it is clearly for the Education Committee to do the lion's share of the work in terms of scrutinising that. There's a motion next Monday. To be clear, I do not think it's the job of this committee to litigate that now. We will all make our views known, I'm sure, robustly on Monday. But I do think that what's happened over the last couple of weeks has thrown up very real questions about civil service impartiality, adherence to the Northern Ireland Civil Service Code of Ethics, and indeed adherence to the Functioning of Government Miscellaneous Provisions Act, which this committee scrutinised and was passed in 2021. I have real concerns about civil service impartiality based on what I've heard in terms of whether it's being upheld or not. That comes on top of other concerns over the last number of years in relation to civil service impartiality, both in the Department of Education and elsewhere. I also have concerns about the adherence to the Functioning of Government Act, which is very clear about what is and is not an official meeting, and burdens that it places on departments and ministers. I'm not clear that those requirements have been followed in this instance. So, notwithstanding specific questions for the Education Committee, I think this committee does need to hear from the Department of Finance, and indeed, if necessary, the head of the Civil Service, about adherence to the Civil Service Code of Ethics. I think this is topical. I think it's important. I think it's germane to some of the post-RHI concern about the civil service. So, can I suggest that we look to, first of all, correspond with the Finance Permanent Secretary around adherence to the next Code of Ethics, ask who's the senior responsible owner overall for adherence to the next Code of Ethics, and indeed adherence to the Functioning of Government Act, and suggest that he comes and gives us oral evidence, ideally next week, but at some point in the next couple of weeks. And look, if the head of the Civil Service wishes to come instead, she's more than welcome. But I think given the public importance of these issues, we do need to be discussing them, not necessarily all the specifics of this trip, which largely relates to the Committee for Education, but the broader issues that are thrown up. I'm happy to bring members in at this point. Deputy Chair.
Thank you. And just to declare at this point, I'm APS to the Education Minister, so just want to put that on record at this point. In terms of this, as was outlined by the Chair, this is a matter Department of Education as to the engagement between the Minister and the officials. I think that in the Chamber that was addressed. I think primarily that it is a matter for the Department for Education. I think that, you know, with respect to the Chair in the position he holds here in this committee, to be making a lot of comments about ethics of a number of senior civil servants is a little bit questionable until there has been any investigation by anyone as to call any of those into question. And I don't really know what legal authority anyone else would have in that, so I wouldn't be in support of progressing this way at this time. I think that the Department of Education should deal with this matter through their committee and bring that forward in that way first.
Okay, fair enough. I'll just bring in other members too. Deirdre Hargey.
Yeah, thanks very much, Chair. And yeah, I suppose I would support your proposal. I know you'd raised this yesterday in the Chamber with the Minister, and he had highlighted in terms of the head of the civil service. So I would support your proposal to get more information from this committee's point of view, from the head of the civil service, etc.
Okay, I'll bring in others. Scherie Carroll was just coming in on Tennyson.
Yeah, thanks, Chair. I was not to rehearse what's going to be discussed on Monday, but I think the Minister talked about a internal review carried out by his Permanent Secretary, if memory serves me right, which I don't think anybody's had said of. So I think it's an equation of like accountability and sort of ministers doing their roles and performing their functions in a manner that is above board. I think it's only right and proper that we follow through with your proposal, so I'm happy to support them as well.
Okay, thanks. If anyone else wishes to come in, Owen Tennyson. And then Brian.
Thank you, Chair, and yes, happy to support the proposal. I guess setting aside the wider rights and wrongs of the issue, there are clearly relevant questions in respect of politicisation of the civil service, ministerial code of conduct, the distinction between party political and ministerial business. And I think it's right that given that we have oversight in terms of civil service via this committee, and indeed we're doing an inquiry that will touch on some of that, it's appropriate that we seek further clarification and further answers on those points.
Okay. I think Brian was first and then Steve Aiken.
Yeah. Okay. Well, my understanding is that this is a matter for the Department of Education and for that committee for education. I understand the Permanent Secretary has said there was no conflict in the Minister's actions. I would comment that I think the politicisation is coming from the MLAs who are trying to find fault because of their political objections, their political views on the state of Israel. And so this was a trip which a number of MLAs and other elected reps took part in and did not conflict with their role as elected representatives. So throughout this, I think MLAs have tried to articulate and find some matter that they can find fault. I don't think that exists. I think this is just part of a witch hunt and a pile-on. So I think nothing will come of it. So we would not, as I say, the Permanent Secretary has said there's not a conflict in how Paul Given conducted himself. So, and I think this is just scraping around trying to give legs to this and prolong it unnecessarily.
Okay, Steve, we'll bring in Steve Aiken.
Yeah, thanks, Chair. And obviously a declaration of interest. I was on the trip to Israel. So 2 key points here as far as I'm concerned. No, I think this should be very much left for the Department or the Education Committee to look at if it's going to be looked at. And the second is to do this when we've also have the example of the Economy Minister who was taking upon herself the roles of foreign policy, defence policy and international trade and politicising the civil service that way. If we're going to do one, we have to do both.
Hi, did you want to come in?
Yeah, just simply to say that the Minister made it clear that he took all the proper steps he should have, and I would feel that if he had to do it again, he would do it the same way, that everything was done in proper order, proper fashion. Thank you.
Okay, well, just reflect a bit. Obviously, we've got to proceed as committee. We're not going to proceed on consensus, obviously, because this is an issue on which MLAs are divided. But I would just say, make a couple of points. First of all, our job is to scrutinise as a committee ministers and departments in relation to our departmental responsibilities. our departmental responsibilities include the Northern Ireland Civil Service and Code of Ethics, so there is no unnecessary politicisation on this on my part, to be absolutely clear about that. This is the work of our committee. It is also the work of the Education Committee in relation to the specifics of that department, but we have a broader and overarching role, including around the functioning of Government Miscellaneous Provisions Act, which, as Dr. Aiken will be aware because he chaired the committee whenever we scrutinised it, was led on by this department, the Department of Education, and imposes burdens on the whole civil service. To be absolutely clear, I, on a prima facie level, am concerned that there's been a breach of the Functioning of Government Act for this reason. It requires that all official meetings which take place are recorded and attended by a civil servant. So if this was an official meeting, it should have been recorded and attended by a civil servant. The Minister has said, I think, in words, that it was not an official meeting. So if it was not an official meeting, then why was a name badge in front of him? But also, if it was not an official meeting, why were official departmental channels used to communicate it? Now, some of those questions will be dealt with by the Department of Education, but they do demand an answer to bigger questions around civil service, impartiality and propriety. That is the function, that is the work of this committee. So I am clear that it is important for us to hear about any broader work that's happening. I should also say that in my capacity as an MLA and in my other hat, I have been corresponding. I've corresponded with the head of the civil service on this matter. She has said she is investigating the circumstances. So clearly there are broader issues for the civil service. That's not politicking, party politicking. It's us doing our jobs as a committee. So members, I just want to crystallise my proposal as chair, which is that we write to the Permanent Secretary of the Department of Finance, copying and the head of the Civil Service, and ask for their view on adherence to the Civil Service Code of Ethics, any issues that have been thrown up in terms of the Civil Service Code of Ethics, and also for the Functioning of Government Act, and ask for an urgent evidence session from SAM, and we'll copy it to the head of the Civil Service, and if the head of the Civil Service wishes to attend, the door's open too. So can I ask for members' views on that? I suspect we're not going to have consensus. Deputy Chair.
Yeah, thank you, Chair. And again, with respect to your position as Chair and bringing this up, I do think it is unfortunate to have this politicking in this committee who generally do work quite well together on this. And just to build on the previous point, you've said that you've separately corresponded with the head of the Civil Service and she's told you she's investigating this with regard to the Department of Education. Did you also ask her, was she investigating the Economy Minister with regard to the call-in?
Yes.
I did not, and that would obviously be completely in order for you or indeed any other MLA to ask that question. Yes,
just to follow up, as I say, you know, you're here in this position of chair asking this committee to do this because you asked, was there an investigation in one instance, but you didn't ask on the other. So to correspond on behalf of this committee for one and not the other, I am concerned with.
Well, I would say there's been, I think, a huge degree of public interest in one. But let me say this, if we have an evidence session, which I think we should have, it would be, of course, perfectly in order for you to ask about any other minister and any other instance. Now, they may not give a specific view, but all of those are examples that you can raise. And that's why I think we should be investigating this, is to have a broader discussion about adherence to the Civil Service Code of Ethics. I'm just going to bring in Owen and then Scherie, and then we'll come to a final view. We may have to divide on it, but that's fine. Owen.
Yeah, thank you, Chair. I mean, in terms of the distinctions being drawn, there is a difference between areas where we disagree politically with decisions ministers have taken and where there are more substantive questions about both the Ministerial Code and the Civil Service Code of Ethics. The reason why I think there needs to be further scrutiny in respect of this particular issue is not because I disagree with the Minister about his views on the conflict of the Middle East. He is entitled to those. And that's not why we're having this conversation. We're having this conversation very specifically because the Civil Service Code of Ethics is clear that official resources should not be used for party political purposes. Now, the Minister, in denying that this was a formal ministerial visit, has exposed a clear contradiction and a clear issue in respect of that requirement. So here's the rub. Either the Minister was there in a party political capacity, in which case the Code of Ethics has been broken because any resources were used to promote it, or He was there in a ministerial capacity, in which case he's potentially broken the law by not having officials present. So this isn't about politics. This is about good government, openness and transparency. And if the Finance Committee isn't going to bring some scrutiny to bear on those issues that are so critical to good government, then I don't know who else is. So I think it's entirely appropriate, irrespective of party allegiance or political views, that we are members of this scrutiny committee. This definitely should be an issue that we are focusing on.
Okay, I'm bringing Scherie.
Yeah, just quickly. I mean, this is a political committee and a political institution, so it's a political proposal that people are happy to accept, and some obviously aren't. So, I think the comparison with the economy minister just doesn't add up, and people are raising their objections to that in a different avenue in Stormont, which is their right. But I obviously don't agree with that. I mean, it's not comparable that the minister is being education minister is being accused of possibly breaking the law, possibly breaking a ministerial code of conduct, and the economy minister who's made a decision in line with sort of international guidance and proposal around taking action to effectively begin a process of taking a decision against a state which has been accused of genocide. The two, in my view, aren't comparable, but I think parties have made their opposition to that in different avenues in the Assembly, which is their right. But I'm happy we to just go with have a vote and on your proposal, sir. Thanks.
Just to repeat the point, this my proposal and the issues that have been thrown up are not about people's views on what's happened in Gaza. We have very well heard strong views. No, that's just to be clear. No, it isn't. And there is a real clear issue here which has been thrown up and is widely talked about in the public square about the Ministerial Code and the Civil Service Code of Ethics. But our job specifically does root the Civil Service Code of Ethics. So, having set out the proposal, and because you do have other business to get through, I would like to crystallise. I think we will have to divide on this because I don't think some of my colleagues in the room are going to be supportive of this, and I think they'd want their votes recorded. Can I ask for people who support the proposal that we write along the lines I've discussed to the Permanent Secretary of the Permanent Secretary of DOF, copying in the head of the Civil Service and the Education Committee for information. Can we have hands raised if you agree with that proposal?
Chair yourself, Jerry Carroll, Gemma Dolan, Owen Tennyson and Deirdre Hargey.
Yeah.
Those against.
And those against?
Deputy Chair,
okay.
Mr. Kingston, Mr. Harvey and Dr. Aiken.
Yeah.
So the proposal has 5 and against is 4, so the proposal is carried.
Okay, just to be clear as well, whenever, happy to comment to bring the Deputy Chair in again if she wishes, just to say, whenever we have our evidence session, whether it's next week or after that, and I do think it should be sooner rather than later, members are entitled to bring up other issues that pertain to questions of civil service partiality, because this is about the Civil Service Code more broadly. It has been brought out into the public domain by this issue, and this is I do think there are very real concerns here for the reasons I've outlined. But that proposal has passed, but I acknowledge without unanimity. But go over to the Deputy Chair.
Thank you, and Chair, as outlined before, it's disappointing to have this politicking coming from the Chair of this committee, and for that reason, as the United Nationalist Front in this committee have put forward their proposal, I would like to make a proposal which, whilst the comment has been made that there's been a lot of concern about one issue, there's been huge concern about the actions of the Economy Minister, so much so that a call-in has been passed by members of the Assembly. So I would propose that we also send a letter in the same vein about the actions of the Economy Minister and the use of departmental resources in drafting and issuing a written ministerial statement.
Okay,
I'll second that.
We have a proposal which is to write to the Economy Minister.
No, right to
the same
Nicol,
as what you proposed.
and the Perm Sec on the same.
Yeah, on the ethics and the use of resources and just exactly what you proposed previously.
This would be a separate letter?
Yep.
Okay. I mean, first of all, I would say I'm obviously happy to put this proposal to the committee because that's what we're here for. I would say, as I said, other issues around the Civil Service Code or the next Code of Ethics it's entirely possible to raise those with the Permanent Secretary when, and indeed the Head of Civil Service when they are here. But I'll just bring in others around this proposal. It's been seconded, so we have a proposal from the Deputy Chair, which has been seconded by Steve Aiken. I'm going to bring in Gemma, then Owen.
Chair, thank you. This is absolutely ridiculous. The Economy Minister did not break the Code of Ethics. She made a ministerial direction, which is completely within her right to do so. So I think it's completely ridiculous and I will not be supporting it.
Okay, I'm going to bring in Owen now.
Yeah, I'm unclear as to what the proposal actually is, Chair. So could I ask just through you to the Deputy Chair? I mean, I pointed very clearly in the previous section of the meeting to the area of the Code of Ethics where I believe there is an issue that we need to explore. So can I ask the Deputy Chair which part of the Code of Ethics is being brought into question here, and what exactly is it that we're seeking to establish?
In order to maintain order, and so it's through the Chair, I will articulate my view, and if the Deputy Chair disagrees with how I've accounted for it, then she can add to that. My understanding is what the Deputy Chair is proposing is a letter expressing concern about what the decisions made by the Economy Minister in relation to trade and investment policy. Is there anything you want to add to that, Diane? Or have I?
Yeah, with direct reference to Israel, which is a very politicised statement, and use of the departmental resources in doing so. Okay.
I don't know if that's answered your question, but I'll just bring in Jerry Carroll, and then we'll move towards getting the committee's view on the proposal. And then
I suppose the last point, ministers are making political decisions all the time, and I think this decision by the Minister of the Economy was the correct one, and I don't see how it is relevant to the Head of Civil Service in terms of breaching of the Code of Ethics in regards to the previous legislation as was referred to. And I don't think it's comparable to say that a minister devolved made a correct decision in line with all the human rights legislation globally. The experts in genocide, UN Commission reports which have said that Israel has committed genocide, and the minister had a duty to respond, and she done the right thing. And people can oppose that, and they've made their views clear on that in the Assembly. I don't see how that's relevant to this committee. So, and I don't see the comparison with that decision and a decision of the Education Minister to basically say to use his role to bolster a state which has been accused of genocide and ethnic cleansing, and to say that it was he's kind of tripped himself over, and that's different aspects of it which is relevant to this committee. So I don't think they're comparable, and I won't be supporting the proposal. Thank you.
Okay. Steve Aiken.
Yeah, thanks very much indeed, Chair. I think what the Economy Minister has done is more severe because, of course, it's gone contrary to the Northern Ireland Act, because issues of foreign policy, defence policy and international trade are not devolved matters. And as a Minister, fully aware of the Code of Conduct and the issues that are laid out within the Northern Ireland Act, she's breached those and has used her civil servants in a manner which has done that. So those are the grounds where I think I'll be pushing sort of the proposal from the Deputy Chair.
Okay, so you'll be supporting that. Owen Tennyson.
Thank you, Chair. I think this just is becoming farcical. I mean, if there are substantive policy questions about a minister acting beyond their vires, it would be entirely appropriate for their own scrutiny committee to explore that issue. What I'm concerned about here is where we have vires, and that is scrutiny around the application of the Civil Service Code of Ethics. And I haven't heard anything articulated which brings into question the Code of Ethics in respect of this particular issue. To be clear, ministers make political statements all the time, but there are limits in terms of the extent to which departmental resources can be used to make those. And it is clear that civil servants, for example, when it comes to a written ministerial statement, may be involved in the initial formulation. They're not permitted to include political statements or political advice within that. That is then handed to the minister and their special advisor, who may make political amendments. So if the proposal from the Deputy Chair is that she wishes to write to seek assurance that the Code of Ethics was followed in that circumstance, then that, to be honest, that's fine, because I'm sure the letter will come back to assure us that that's the case, and it's reasonable that we get that assurance. But I'm still entirely unclear what the allegation is, and to write and express concerns when actually no substantive concern has been articulated, I just don't believe is appropriate. It really is just a race to the bottom of tit for tat, rather than engaging substantively with the issues that this committee is responsible for, and that is the Code of Ethics itself.
Okay, I'm going to go to Brian Kingston now.
Well, it is ironic to hear some members now moralising about not wanting to waste time and interfere in matters that aren't the concerns of this committee, when that's exactly what they've just voted for. If they do not support the proposal in relation to the Economy Minister, it will be totally clear and apparent to all observing this that this is about politics and not about principle. What the Economy Minister has directed Invest-NI officials to take on her political views in not supporting companies in the defence industry who might be supplying arms to Israel. That is imposing her political views on her own officials. Also wanting Northern Ireland to be excluded from UK trade talks with Israel. These are imposing her political views and, as I say, asking officials to take on her political views. That is inappropriate and that has rightly been challenged. So if this committee has any principle in its mind, it would support this matter if it has supported the previous request, which was done on a division without our support. Okay. But having taken that decision, then the committee should at least prove that it is going to be even-handed and not acting in a purely political manner. Okay,
I'm going to bring in Gemma Dolan. This is the final one, and then I'll move to the proposal.
Yeah, Chair, I think we do need to move on a wee bit here, but like Brian's saying that the Minister asked for officials to act in a political manner. Is that not what political institutions are about? She didn't abuse her power. She's using her power, whereas the Education Minister clearly abused his power. Scherie.
Okay, we have.
But she doesn't have that power. That's the point.
Through the chair, Steve.
I wasn't talking to you, Steve.
Order, members. This is about us focusing on specific issues which relate to the Civil Service Code of Ethics, which is why I've made the proposal. But another proposal has been made from the Deputy Chair, which I'm now going to put to a vote, and then I'll discuss actions after that. The Deputy Chair has proposed that we write an additional letter to the Department of Finance or to the Permanent Secretary around the Code of Ethics, specifically in relation to the Economy Minister. I'll just briefly say my view on that. I think it's entirely for individual MLAs and indeed parties to raise these issues. I am personally, as yet, unconvinced that the specific issues around the Code of Ethics are touched in that regard in the same way as they have been in relation to the Education Minister, but it's a completely reasonable request for the Deputy Chair to make. So we'll put it to a vote. So those in favour?
We have Deputy Chair, Mr Kingston, Mr Harvey and Dr Aitken.
Okay. And then those opposed?
The Chair, Ms Hargey, Mr Carroll, Mr Tennyson and Ms Dolan.
Okay.
So that's 5 opposed, 4 for. The motion therefore falls. Chair.
Okay. I just want to say one thing in relation to this. Should we have an evidence session on Civil Service Code of Ethics matters, it will be about the broader interpretation of the Civil Service Code and issues around all of that. So members will be able to ask questions about a broad range of things, and they will not be curtailed in doing so. But at this stage, having had a good but robust exchange of views, I'm going to move on. Members are content? Okay, we're now going to go on to agenda item 4, which is draft minutes of the meeting held on the 22nd of October. So members, they're at page 90 of the meeting pack. Are members content that those minutes are a true reflection of the proceedings on the 22nd of October? And if so, I will sign them.
Members content.
Content? Okay. Now, agenda item 5 is matters arising. First matter arising is at page 104 of the meeting pack. It relates to correspondence from the Minister of Finance regarding his request to the Treasury for access to PSNI data breach compensation. As members will recall from the last meeting, the request was denied, and this committee agreed to seek further information from his department in this regard. This has now been received. In actual fact, we got it before the break, I believe, did we? But we had it for the last committee meeting, but we were only just getting around to having it in the pack. So I don't know if anyone wishes to come in on that, but obviously I think we've given our views in general about the reserve claim, and the Minister's told us about it, and we have asked, I think, the Department to keep us abreast of it. Members content with that? So 5.21 is a series of DALO readout responses from 22nd of October. The first one is also in relation to the data breach compensation. It highlights that the Minister will continue to make representations to the Treasury. He will also work with the Justice Minister and other executive colleagues in this regard. Due to legal proceedings, a breakdown of the figure to settle costs cannot be provided. The potential for the new NI reserve is expected. The potential for a new Northern Ireland reserve is expected to be part of the discussions with Treasury. This has come up in our committee before. Obviously, we don't have a reserve, unlike other devolved institutions. The PSNI and DOJ will have sought their own legal advice on a range of possible scenarios if the compensation payments are not made in this financial year. So this is to note, members, but I do think it's really important that we ask to be kept abreast, sort of in real time about this. I would hope we will find out about it one way or the other.
Chair, it might be something the Minister can update on
the 10th of December.
On the 10th of December.
Yeah.
Because if there's discussions going on as part of the fiscal framework, then there should be some indication of where that is headed. So it might be a useful one to put onto the list.
Okay. Members are content with that? Yep. Page 5, the tabled pack. This also relates to reserve claim, but a different one. The department has confirmed that it has not received a reserve claim in relation to the redress scheme for those affected by the mother and baby institutions and the Magdalen laundries. So members, this is really to note and forward it to the TO committee for consideration. Members are content with that? So 5.2 is from the Minister for Finance, and it relates to a response to our response from him in relation to the inquiry on banking and financial services, on page 105 of the meeting pack. The Minister highlights that he has organised a further banking roundtable in December, and that he has organised a drop-in event for MLAs on the 2nd of December to raise awareness of its access to cash assessment process. A detailed assessment of each of the committee report recommendations have been included with the response. So, members, I just wanted to say briefly about this. I mean, it's welcome that we've got a fulsome response. I suppose the only point of disappointment, and I mentioned this before, is that we don't yet have a clear, I guess, agreement from the Minister and the whole executive to, I suppose, be pushy and focused on financial services writ large. The Minister says in his response, I will continue to press in the banking sector for the full road of banking hubs. That's important. He also says he says, rest assured, I will continue to press on those responsible in London to take action and set out in the committee's report, if presented with opportunities at cross-border and jurisdiction body meetings, I will advocate for tailored solutions locally. I suppose my comment, but I'm only making it individually, is that I would wish to see more than simply taking opportunities if presented and pressing. I would want to see a more coherent and consistent form of pressing for opportunities. Otherwise, things like the banking and financial services roundtable really are just engagement exercises without specific set of outputs that are focused. I don't know if anybody wishes to come in on that, but it's really, that's really all I want to say about that. But otherwise, I appreciate that we have got good, detailed responses to lots of things. I think we've done that one already.
That's the economy one.
That's the economy minister. What page are you on? Actually, yeah.
No, it is that one. Yeah. Sorry. Yeah. Okay. Sorry, members. The agreement I was is in my notes to seek is a briefing from departmental officials in 6 months' time to assess progress towards assessing committee recommendations. If members are content with that, so that will be at some point in 2026 that we have, and we'll be able to follow up on our recommendations at that stage. Okay, members. 5.23 is a DALA readout response relating to from the Economy Minister, or in relation to engagement from the Finance Minister with the Economy Minister and Department. It's at page 6 of the tabled pack. The Department has confirmed that the formal response from the Finance Minister was submitted this is the response to our report, and that response underlined the Minister's engagement with both the Department of Economy and with credit unions. So that's just to note, that's what we had asked to update us on engagement in relation to credit unions. Now I'm going to item 5.6.
Chair, if we go to item 6, because officials have arrived, and I'm just conscious.
Okay. Sorry, I'm being told
we need to do that briefing because we'll have the OECD briefing.
Yes, okay.
And it's a very specific
window. We may need to go back and do manager rising next week.
We need to go back.
That's fine.
If members are content,
we'll go to item 6. We're going to go to oral evidence. We're going to committee deliberations. Yes. Item 6. So members, at page 466 of the meeting pack, there are a number.
Sorry, item 7, Chair, my mistake.
Oh, item 7. Okay.
Sorry.
All asunder. Fair enough. We're now doing our oral evidence session on the Public Office Accountability Bill. And we're having an oral briefing from the Department. Members, that's at page 582 of the pack. There's a clerk's memo in relation to the legislative consent motion on the Public Office Accountability Bill. Also included for information is correspondence to the Minister of Finance at 584, a legislative consent memorandum laid by the Department of Finance at page 654, and at page 20 of the table pack, a revised legislative consent memorandum, which was laid in the Assembly Business Office yesterday on the 4th of November. This highlights errors in the previous memorandum, which is paragraphs 20 and 27. So, members, we're now going to get an oral briefing from departmental officials who will give us an update on the timescale and extent of an LCM for this bill. This is obviously a Westminster bill and is most associated with things like Hillsborough and Grenfell. Obviously the Executive is currently considering precisely its approach to this. The Minister's given broad indication of support, but this will give us a bit more of a sense of where we are and NI-related implementation and issues. We're joined by David Hughes and Jonathan McNaught. David's Director of Corporate Services at the Department of Finance, and Jonathan is from Corporate Services Division at the Department. So, David, please do give us an opening statement.
Thank you very much. I'm very grateful.
And members obviously indicate for yourself first.
Just to get members' agreement for this to be Hansard.
Hansard, yes, of course. Everyone, I presume people are agreed with Hansard.
That's great.
I'm grateful for the opportunity to brief the committee on this bill. What I'll do, if it's okay, I shall walk through the relevant parts of the bill and then set out some of the context, which I trust will be helpful. The bill has its origins in the campaign for legislative change in light of the findings of the Hillsborough Independent Panel, and members may recall a private member's bill being tabled in Parliament earlier this year to achieve these ends, usually referred to as the Hillsborough Law. The Labour Party had committed to legislating once in government, and this is the bill that's been introduced to meet that commitment. It replaces the private member's bill. So the immediate context is the Hillsborough disaster, but the intention behind the legislation is to transform the behaviours of public authorities and public officials generally and address failures that have been identified in other inquiries and investigations. Fundamentally, the objective set out in Clause 1 is to ensure that public authorities and public officials at all times perform their functions with candour, transparency and frankness and in the public interest. The UK government view has been that this bill should ideally apply UK-wide, and that the provisions, including the duty of candour and the new offences, provide a package of measures designed for cultural change and accountability. In our own context, the Executive agreed in December 2024 to explore whether our inclusion in this bill would serve to meet Recommendation 5 of the Infected Blood Inquiry, and I'm aware too that there has been interest in its relevance to the Chinook crash in 1994. The bill was originally to be published earlier in the year with a target for introduction before the anniversary of the Hillsborough disaster in April. Short timescales meant that executive agreement to inclusion in the drafting of the bill was sought under urgent procedure and was given on a provisional basis, acknowledging that there wasn't time to do a proper assessment of the implications and the impact of the clauses. The Minister set out to UK ministers that agreement to the provisions extending here was conditional upon an assessment of risk prior to any legislative consent motion being introduced. The bill was not in the end introduced in April, but continued to be developed over the spring and summer. And during this time, although at official level we saw drafts and discussed policy with UK officials, we weren't able to engage outside our departments with the wider range of public authorities. Consideration of the clauses was therefore somewhat limited and couldn't inform ministers' position any further. So there has been internal discussion of the clauses, some of which have, with ministerial agreement, been drafted to extend here, some of which it has been agreed at ministerial level ought to be drafted to extend here but have not yet, and some of which are still under consideration. The Department hasn't yet brought a legislative consent memorandum. That will depend upon executive agreement to do so. This is without doubt a cross-cutting matter since it engages the public sector in its entirety. And then the Executive's decision will be informed by inputs from across the departments and reflecting the views of various stakeholders which departments have been garnering, as well as, of course, the views of the committee. The provisional position, though, is informed by two principles. Firstly, there is a basic expectation that public officials and public authorities here shouldn't be held to a lower standard than those in Great Britain. Secondly, this is intended to be the Executive's response to the specific recommendations of the Infected Blood Inquiry in parallel with the response of the other administrations. So I'll set out the shape of the bill, referring both to elements that currently are drafted to extend here and to other elements which may be extended here. Part 1 is the Purpose Clause, no direct legislative effect, but sets out the intent of behind the bill. Clauses 2 to 8 Part 2, Chapter 1. This creates a duty upon public authorities and public officials to act at all times with candour, transparency and frankness in dealings with inquiries and investigations. There's a duty to notify the person leading an investigation or inquiry that one has relevant input to make, and a duty to provide all such assistance as one can reasonably give. That duty is always, as it were, switched on, but there are provisions which allow the person leading the investigation to switch off the duty to notify in cases such as the COVID inquiry where there is an imperative to manage the sheer volume of relevant inputs. The duty of candour and assistance applies to all public authorities and public officials, and these are defined in Schedule 2. The duty is also extended to include anyone with, and I quote, relevant public responsibility. That might be, for example, a health and safety responsibility in a specific case, or as a service provider with a significant impact upon members of the public. There's then a criminal offence of failing to comply with the duty of candour and assistance. Schedule 1 makes amendments to the Inquiries Act 2005, the Coroners Act 1959, and other legislation to embed this duty within existing statutory frameworks, and also makes specific arrangements about non-statutory inquiries. It provides powers to apply the duty to specified investigations or a specified type of investigation, and that includes a power for relevant Northern Ireland departments to make regulations. These provisions have been drafted to extend here, including Schedule 2, to ensure that it has equivalent effect here and covers the same public authorities and public officials. Clauses 9 and 10, that's Part 2, Chapter 2, place a duty upon public authorities to promote and maintain high standards of ethical conduct at all times. Specifically, authorities must adopt a code of ethical conduct, publish it, and make people aware of it and the consequences of breaching it. There are specific details which have to be included, starting with an expectation that people working in the authority will act in accordance with a duty of candour in matters relating to their work. Part 2, Chapter 2 applies to public authorities, but according to a slightly different definition of public authority to that applying to Part 2, Chapter 1. I apologise that this is quite convoluted, and I have to remind myself of it every so often as well.
Yeah.
The definition for Chapter 1 includes bodies performing functions of a public nature. The definition for Chapter 2 does not include that general public functions test and is therefore a bit narrower. Clause 11 creates a criminal offence of misleading the public. It's intended to address instances of deliberate and seriously improper conduct. It's also important to note this refers to acts to mislead the public in general and is not intended to capture individual interactions. This provision was drafted relatively late in the development of the bill, and there has not been time to draft the intended extension here. Nevertheless, the Minister has indicated that he is content in principle that it is extended here, subject to the legislative consent motion. So we anticipate that that extension will be effected by amendment during the passage of the bill. Schedule 3 contains some details about the nature of the new offences created in Clause 5 and Clause 11. Clauses 12 to 17 relate to misconduct in public office. These provisions abolish the common law offence of misconduct in public office and replace it with two new statutory offences. The first consists of using public office to obtain a benefit or cause another to suffer detriment, and in so doing committing a seriously improper act. The second is the breach of duty to prevent death or serious injury. The intention is simply to replicate the parameters of the common law offence within a statutory framework, and therefore to provide greater clarity and certainty for the justice system. These provisions were originally recommended following a Law Commission review of misconduct in public office published in 2020. This bill has provided a vehicle for making this legislation, which, although it doesn't itself flow from the Hillsborough disaster or any specific inquiry recommendations, nevertheless is equally concerned with standards of behaviour within public service. Schedule 4 then sets out who is caught by this provision, that is to say, who holds public office. It's worth noting that this is a different definition to the definition of public authority and public official in Schedule 2. The difference is essentially that a holder of public office will be someone in a position that really only exists in the public sphere. Ministers, civil servants, the armed forces, police, judiciary and so on. It doesn't include, for instance, doctors and teachers. and that reflects the existing parameters of the common law offence of misconduct in public office. Now, although this provision has not been drafted to extend here, the Minister has indicated that he supports the extension of this provision. The common law offence in this jurisdiction is, to all practical purposes, identical to that in England and Wales, and has been used in broadly similar ways, albeit on a smaller scale. We anticipate that the extension should be achieved by amendment during the passage of the bill. Part 4 comprises Clause 18 and refers to Schedule 6. This applies only to England and Wales, extending legal aid to families at inquests and making provisions governing the activity of public authorities and at inquiries and investigations. Part 5, clauses 19 to 26, includes application to the Crown, on consequential repeal, powers to make regulations, interpretation, extent and commencement provisions. The next steps will be for the Minister to bring a paper to the Executive seeking a decision on a legislative consent motion. This will need to address provisions that were not in scope at the time of the original decision in March, and it will also need to assess what risk is attached to following the policy being set by UK government, informed by the engagement the departments have been doing with their public sector stakeholders. The stage we're at in the process, second reading of the bill was on Monday evening. The next stage, Commons Committee, is expected to begin in late November. Thank you.
Okay, this is a very, very big one, and there'll be lots for us to scrutinise and also to, I suppose, first of all, just to kind of crystallise where we are, and I'll bring in members with Deputy Chair, then Jerry Carroll, then Brian, and obviously anyone else who wishes to ask and indicate. Is the position? So the position is, if I've understood it, that the Minister supports in broad terms the provisions in this bill, but has not yet brought forward a formal proposal to the Executive that the Executive agrees a legislative consent motion.
That's right. It's clearly one where the Executive as a whole will need to take the decision to support the legislative consent motion because it's cross-cutting.
Yeah.
The Minister of Finance is content that, in principle, this is legislation that should extend here,
yeah.
But because of the pace with which the bill was developed, including some very late inclusions, consideration of its impact and any risk that might be attached, and because of the need to engage stakeholders outside the departments, that sort of final recommendation to the Executive can only be made once we've had the opportunity to go through the stages of examining it with stakeholders and partners.
So who are the stakeholders whose feedback you are seeking?
Well, each department has been invited to go out to their public sector employers, the authorities and the public office holders and officials that the bill will capture, in order to get the insight from those employing sectors, as it were. So, for example, the Department of Justice will be engaging with police service, also with prison service within the department, and so on. And I know that the Department for Communities would be engaging with local government, and Department of Education with the education sector, and so on.
And when you say the sector, so for example, in relation to the education sector or the health sector, does that mean, does it just mean the Department of Education is going to the Education Authority, the Health Department is going to the trusts, or does that mean they're going to the teaching unions and Unison and the RCN and whomever? Are they going to trade unions too?
It will be for the departments to determine how they engage with stakeholders. For the Department of Finance, clearly our principal stakeholder, as it were, is internal, in that the interest is in the civil service. That's
for the department, okay, but you're the senior department, you're the
lead department.
The lead department for the whole of the devolved government. Okay. What's the deadline? What's the timeline or the deadline for this? Obviously, it's begun committee stage at Westminster.
Yes. So we would need to have a decision on the legislative consent motion before third reading, which won't be until the new year. So the intention is that we should be going to the Executive end of this month. This is November, isn't it? Yes, end of this month.
It should go without saying, and I presume you have in mind that we would not like in any way a repeat of the data use and access bill.
We're trying to keep as much hold on this one as we can.
And obviously, because that would be very difficult, particularly if have there been any entities that have come out strongly against? So, for example, in relation to healthcare, in terms of a duty of candour, or specifically in relation to health, several of the professional bodies aren't keen on that. Where are the public sector trade unions more broadly here?
We haven't had any very strong responses against.
Mm-hmm.
I think there is a recognition of the value of what it's trying to achieve.
Yeah.
And I think there is also a recognition that, to all intents and purposes, what this is doing is creating a statutory framework around what is already being expected. So it's not creating very much that is new, except that it is now in statute.
Okay. One final question before I bring in others is part 2 of the bill, say under public authority, which is part 2. Sorry, is this a schedule? This is the schedule. Sorry. It talks about public authority. Part 2 of the schedule, which talks about the meaning of different things and what things mean, which is obviously what schedules often do. It talks about a public authority means a government department, a minister of the Crown, the Scottish ministers, the Welsh ministers, and Northern Ireland devolved authority. Or is there a reason why Northern Ireland, is that a common, is that regularly how this is done, or is there a reason why it's not Northern Ireland ministers as opposed to in the same way it's Scottish and Welsh ministers?
Because, now, let me find it, there is then a definition elsewhere of a Northern Ireland devolved authority,
okay,
which means First Minister and Deputy First Minister acting jointly, a minister, department.
Okay,
so it's just
enough.
Summarising those.
Okay, that's helpful. I'm going to bring in others now. Deputy Chair.
Thank you, Chair, and thank you both for being here today to take our questions on this. With regard to the new duties around candour, I just want to ask, will these be retrospectively applicable whenever we're going to be dealing with historical investigations and inquests?
It will, my understanding, and I'm going to say that a lot because possibly colleagues in the Whitehall departments would be able to give you chapter and verse. My understanding is that it will apply from the point at which it is commenced.
Where we would then go on to begin a new historical investigation or a new historical inquest on something in the past?
Yes.
The duty
it will relate to that inquiry as it starts.
Right,
yeah.
Okay. Thank you very much for that clarity. And just, you touched a wee bit on the timeline and the amount of detail in this, and I just wondered when you would expect that the other remaining elements of this bill and the LCM would be discussed by the Executive?
What we're intending is that it should be taken to the, advice should be taken to the Executive by the end of the month.
Thank you very much. Thank you, Chair.
You happy? Jerry Carroll.
Yeah, thanks. Just kind of following on for the Deputy Chair. So if the Executive approves, we're probably looking at early next year for an LCM discussion on the floor of the Assembly.
Yes, I think that's right in terms of timing, because the Assembly rises in mid-December.
Yeah, no problem. And in terms of, I think it's been touched upon already, but obviously myself and other MLAs have been involved in different groups who have kind of raised duty of candour in a general sense, concerns, former neurology patients and others, that there's a long list of them. Like, I hope that, I know there's a bit of nuance between, like, as the Chair said, some unions have more of a specific demand around what type of duty of candour is in place, and some patient groups obviously want, maybe a different kind or something a bit more robust. And I'd be concerned that maybe the LCM and the legislation, it may meet their needs or it might not. And I think really, like, with respect, David, I think you said it's up to individual departments, and many patients, former patients, would feel like let down by those departments. I think they need to be a bit stronger from a Department of Finance perspective, and either issue a directive to departments to say, I think these groups need to be included in any consultation, and that's kind of a bit long-winded, but I think it's an important point that these people feel that this bill is central to them. I think people in England and the Hillsborough victims I think, feel that, and obviously it's named after them, and rightly so. But I don't know whether the sort of victims groups, former patients here who've been let down by departments, whether they feel that, you know, the bill is kind of their bill as well, which it sort of is. So that's a bit of a long-winded way of asking is what's the consultation process? I mean, obviously it's an LCM, but is there a timeline for consulting with people who could effectively avail of this legislation?
The process of consultation will be that consultation that individual departments are having with their sectors. I'm aware that the Department of Health already have an agenda around an organisational duty of candour, which they have their own programme of work heading in that direction, looking to ensure that within the health sector here, the same organisational duty will exist as already exists in England, Wales and Scotland, which doesn't currently exist here. This bill has been developed and drafted in the context in which that organisational duty already exists in Great Britain, and therefore it kind of leaves those issues to be pursued by the Department of Health according to its own agenda that's already been committed to. In terms of consultation, because we have been very limited in the time that's available, the most effective way we have felt has been to ensure that departments are going to their employing sectors, and that then should inform the discussion at the executive, because every minister will be around the table knowing what the position from their perspective would be, from their sector and from their area of responsibility. And that's the way that we're able to take it forward in the short timescales available.
Yeah, I appreciate that, but I would strongly suggest that I think those groups who have called for duty candour, and even some of the ones that the chair mentioned, should be their views should be sought for. Probably save a department maybe a few issues down the line. So I would really emphasise that should be the approach taken. You know, they're sought out specifically on the bill and their issues around it. But thanks.
Okay, thanks, Scherie. Just before I bring in Brian, just to double check. So if their departments are going out now, is it not a wee bit chicken and egg in the sense that because it's a legislative consent motion, going out and seeking opinions on a legislative consent motion might risk obviously these are, particularly if they have policy teams, they will know the difference between a legislative consent motion and Stormont initiated legislation, but is it being made clear to them that you can give us your views on the totality of this legislation, but that doesn't mean we will be able to change it, and even if theoretically or hypothetically the executive decided not to support the application to Northern Ireland of this legislation, in all likelihood the UK government would proceed with it anyway, and indeed if there were specific amendments or suggested changes that were advocated by those groups, there would be a limited opportunity to get them in. So I suppose, are you managing expectations in that way?
The framing of the consultation between departments and employing sectors has been very clear that it should be to look at the bill in its entirety and to flag any issues or risks that they feel that ministers ought to be aware of when taking a decision whether this should apply here.
Okay, that's helpful. Brian Kingston.
Thank you, Chair. Thank you for your attendance today. I'd have to say I welcome the general approach of trying to ensure Northern Ireland is included in the bill, rather than quite often we just have this delay where we're playing catch up. So I hope that can be achieved so that there is the same protection and the same requirements on people here. In terms of two particular questions, in terms of Clause 5, the offence of failing to comply with duty, I'll just read what it says here. A person commits an offence if they fail to comply with the duty of candour and assist in respect of an inquiry or investigation, and they intend that their failure will impede the inquiry or investigation achieving its objectives, or in the case of a failure to comply with it, an obligation arising under those sections are reckless as to whether it will do so. I'm wondering what the outworking of that will be for ordinary workers, if there is some wide-ranging, and I notice that inquiry and investigations are with a small I, So again, I'm not sure whether you're in a position to comment on. My concern is that workers would feel that the offence of failing to come forward, if there was some wide-ranging inquiry on a wide-ranging health matter, or some wide-ranging safety matter, that people aren't thinking, well, I don't think that applies to me, but I'm wondering, should I somehow come forward, because they don't want to find themselves being accused of the offence of failing?
Yeah, I think it's very important that they have both the positive support and encouragement to candour in a public official capacity, and that's the positive responsibility, which is supporting, encouraging good practice generally. The offence, actually, that it will relate to intentional, and if not intentional, reckless, with the intention of impeding.
Yeah.
So it's very definitely doing the wrong thing as opposed to failing to do the right thing. That's certainly my understanding and reading of that. And where it refers to inquiries, investigations, although it does have small i, it does apply to specific inquiries and investigations. It's not every single time someone asks a series of questions to find out what happened. It's very definitely a category.
Right. So you think the intention is to have a sufficiently high enough bar that somebody thinking just because they had some dealings with the matter in their work duties, it's only if they're in the category of deliberately impeding an investigation?
Yes, and it's also worth remembering that those duties apply to authorities and officials, and where a public authority can contribute to inquiry, there's a responsibility on the person who leads that authority to manage the interface. That's certainly my understanding. It's not a free-for-all for tens of thousands of people working in a sector, everyone fires in, but rather where a body or an organisation or an institution can clearly contribute, then there needs to be a management of that interface.
And the other question I have, you referred briefly there to about individual duty of candour. Did you say there was some other process coming forward on that?
I'm not over all the detail, but there is work towards an organisational duty of candour for the health sector, which is something that would be reflective of the position in Great Britain.
There's work on that locally then?
Department of Health is in the lead on that.
Right. Okay. Thank you, Chair.
Okay, no problem, Brian. No one else at this stage has indicated that they wish to come in, members. So at this point, I'm going to thank David and Jonathan for coming and giving us evidence. I suppose, finally, can I ask, so end of this month, am I right in saying that you anticipate a decision being recommendation being put to the executive from the Finance Minister? And just to remind me then, what's the deadline you've given departments? Presumably it's before then, it must be in the next couple of weeks.
It's quite shortly, yes.
Okay, and at that point the expectation is the Finance Minister will make a recommendation, and the recommendation will have to be broadly either, I'm not presupposing one way or the other, although he's indicated broad support for it. I mean, certainly on behalf of my party, and others have indicated I would support this bill, but it's either support the bill being applied as is to Northern Ireland, number one, support the bill being applied with specific requested, but with no guarantee the requests will be acted upon, changes, amends. Number three, say, we like it, but we're going to take us out and we're going to do our own whole bill and see if they agree to that. Or number four, take us out altogether, which is unlikely and, in my view, undesirable. But those are basically the four options, I'd say.
And I think it's worth bearing in mind that the communication with the bill team in Whitehall has been very good.
Okay.
And so managing what amendments need to be made at a committee stage and the timing of those and the timing of an executive paper should then reflect what is actually in the bill and what will be in the bill as a consequence of the Minister of Finance's position that it should extend.
Okay, that's really helpful. Please do keep us abreast and as quickly and in as timely a way as possible. And we appreciate both of you coming to give us evidence today. So, members, I don't think we need to I think there's no further follow-up points that are.
It might just be useful to remind members that the Health Minister did make a statement indicating he would be likely to bring forward a health-specific bill. I think that's the reference to the Health Department making their own, following their own process. So that's kind of one to watch out for. But
okay, great. Thank you very much. Cheers. Now, members, agenda item 8 is it's basically this finalising priorities in our civil service reform.
Chair,
apologies, sorry, Brian.
Sorry, Chair. Well, just before we move on, should we write to the Minister just for clarification? Or whether it's to be raised at the executive. It's just the time scale seems quite tight there.
Yeah, I'm happy. We could just ask the DALO if you're happy.
We could put that through as a DALO request if we can get a specific time scale of which executive meeting they're actually aiming for.
Yes, I think that is important because it's now quite tight for time, yes. And they've gotten to. So yes, I think that's fair enough.
Chair, once it goes through committee and it hits third reading, that is the golden time when any kind of issue change or assembly agreement is really most relevant. Once you get beyond that,
so with that
times are the committee, the assembly's input out.
Yeah, like if there's any Northern Ireland specific thing that we wanted included or even reflected in the Hansard of the debate, then it would have to happen in the next few months, and before it goes back for.
Just to ensure at our end,
yes.
Things are progressing, and I mean they will be aware of the time scale. But anyway, I think we'll just do our job.
Yeah, I think that's completely right. Given that we had a previous
question.
That's completely fair enough. We'll do that.
Chair, I do have to say a very positive thing that has come out of the last issue we had with an LCM is the department on both this process and the other one we're looking at around cybersecurity. Officials have been in regular contact, so we do feel much more in the picture and much better informed than we have previously, and that's to the department's credit.
Okay. That's helpful. So, as I say, we will do that. Agenda item 8 is around priorities for civil service reform. Members, I don't propose to have a detailed conversation on this because we can bring it back for more detailed discussion once people have had a chance to look at it. We did agree at our strategic planning day that the inquiry should focus on people, i.e., rather than estates or any number of other things we could focus on, including all the things we've talked about around vacancy, management of senior people. Strategic HR, but do you want to give the 5 themes, Clark? And then
Sure.
I would suggest members either feedback now or more likely in writing. Or
the themes we've ended up with, Chair, are discipline policy, which members have come back to a fair bit, use of temporary promotions and the impact of unfilled vacancies. And again, that reaches into the third item, which is sick absence. We've got a fair bit of information now, and the department's working on a lot more data around that. So as we move on, I would hope we have a lot more information. Fourth one is the hybrid working, which is now under review, which will have tangential impacts on some of the stuff that the committee isn't focusing on, particularly such as the estate strategy and so on. But I suppose that fifth one, people strategy 2025 to 30, is the overarching, where is the civil service going, what reform are they looking to pursue, and that's kind of where the committee's inquiry is ultimately heading, is what does the civil service need to look like to be fit for purpose going forward. So the other issues that are listed that members had talked about during the strategy session, it's not that those will fall by the wayside. They are things that the committee will come back to and will have regular updates on the likes of the RHI recommendations and the Public Sector Transformation Board and the estate strategy, etc. It's just they won't form part of the core people-focused themes within the inquiry itself. If there's a need to reference them, we will do that. But it's a case of focusing on those other 5 primarily. So Tom's already started in the terms of reference looking at that. So probably what we'll want to do next is bring that to committee, and that will possibly then need a bit of discussion and debate. But if there's any issues that members have around the 5 that have emerged or want to add to those, if they want to get in touch, we can look at amending that and bringing it back. But that's pretty much what emerged from the strategy session, Chair.
Okay. Members are broadly content with that? Brian?
Just to clarify, is the volume of agency staff, is that included in that?
That will come into, that's the use of temporary promotion and unfilled vacancies. So we've got a fair bit of good data on that.
Yeah.
Also, how long-term sickness absence is managed. There's often use of agency staff to cover that, where temporary promotion isn't available or wouldn't work. So it actually feeds into a couple of those. So yes, absolutely, there'll be a look at that as well.
Okay. Members are content. We'll bring back the terms of reference in the next little while, and we can formally agree that. If members do any other specific additions, they can let us know. Okay. Mm-hmm. So,
a bit of time. We can go back to matters arising.
We'll go back to matters arising in that case. You had to get through them. Right. Okay.
Page 7.
Okay, we've got a lot of matters, so we'll try and get through some of them because we are okay. So,
we do about 10 minutes.
5.3 is members the consultation on use needs census. Is it called use needs census? User needs.
Sorry, that was.
No, don't worry. User needs census 2030. We are a user in this case, or we're a potential stakeholder. That's at page 113. The department has informed the committee that it is embarking on a 14-week consultation to gather insights on user needs for future census statistics ahead of the 2031 census. So if anybody, Deputy Chair, which I think was...
Yeah, thank you, Chair. Just on a quick look through that, I don't see any reference to gathering data on veterans or service leavers, which you would typically see in other regions. I just wonder if the department has any particular reason why that hasn't been included at this time. Obviously, it can be fed back into the consultation, but I just wonder if there's any particular reason for that, if we could find that out,
yeah,
please.
we can ask, yeah, definitely. Okay, if everyone else is content, we will do that. 5.4 is the December monitoring round. At page 205 of the meeting pack, there is the department has formally commissioned returns on the December monitoring round. Returns are required by the 20th of November. Now, there is something which intrigued me when I read this, but I've now forgotten what it is, which is helpful. I made a note, but I've now completely forgotten what it is, which you'll all be delighted to hear. So we'll move on. Okay. Members are content, but members, if you're content, we will get a breakdown of which departments meet the 20th of November deadline. So 5.5 is relates to the write-off of the Mutual Society loan. That's at page 214 of the pack. Now, we discussed this in hard copy at our last meeting. Members will recall the Department of Finance laid a minute indicating that it was to write off the repayment of an NI consolidated loan fund made to the Presbyterian Mutual Society. At the last meeting, we agreed to request further information from the department. That has now been provided. That actually begins at page, I think, 215 at the following page. Page 7, apologies, the tabled pack, is it?
It's the response from the department.
The response to the department, sorry, is at page 7 of the tabled pack. So members had asked for some additional points. Does anybody wish to raise the, does anybody wish to talk about what, so it's it's page 7 of the tabled pack.
It's item 520.
Item 5.24.
Yeah.
I don't know if anybody, I'm not sure actually which individual member raised it, but I think it was Dr. Aiken actually, but if anybody wishes to come in, it's...
Thanks, Chair.
Yeah.
No, it's just seemed, it's interesting that they pointed it out, but I'm still not quite sure of how they managed to do it, if you know what I mean.
I don't totally know how they managed to do it, as in how they've managed to get through the write-off in this way, or...
Yes, I mean, again, it comes down to, it seems a very unusual, and I think the Deputy Chair would be much better bearing in mind their formal qualification in accounting and how it's managed and how the monies were written off.
I think, as you will see from the way what's in their response, this was effectively written off, as in the value of it became nil in the 2011-12 annual report of the department. So it was I'm not an accountant like others in this committee, so it was effectively written off then. But and I think the rules have changed a lot now. Obviously, post crash, there were new institutions were created. I think this is a relatively comprehensive response that we have. It is of historic policy interest, and obviously it was important that the as it were innocent shareholders and users of the Presbyterian Mutual Society were protected. But I think we have now a relatively comprehensive response. But Deputy Chair, wish to come in.
Yeah, thank you, Chair. And just on that, just again to reiterate, it was just such an unfortunate time for all of those involved. But in terms of this, I think that it's fair to say it is a comprehensive response, and it is clarifying that it was always accounted for in a quite a prudent way, that they weren't expecting it back, and the loss has been fully captured in previous financial years. So I think whenever we initially got it in paper copy and hadn't had time to process it last time, we thought there was going to be a big write-off, which would have been a cost to the current financial year's accounts, which this has made very clear that it has sat there and the loss has already been recognised in previous years. So it's no actual hit to the block here. It's just quite procedural. So I'm satisfied, I think, with that response, and that there's no direct impact on this current financial year.
Indeed.
Chair, if the Deputy Chair with their considerable sort of accounting acumen is happy with it, I'm happy with it.
Okay, there you go. Your accounts are signed off by we'll all be ringing in our tax returns next week. Brian Kingston.
I see the reply there. I'd asked the question last time about the being registered with the FCA and the Financial Services Compensation Scheme, which was one of the difficulties that the Presbyterian Mutual Society had not, which is like an insurance scheme really for banks and investment organisations. And you'd have to assume they were saving money by not paying into that insurance scheme, which was part of the reason why their investors were left so exposed and not compensated when there was a run on their funds. The reply here is that public investment and deposits would typically be required to register with the FCA and comply with financial services legislation, which would ensure members are protected up to £85,000. So the reply isn't as watertight as I hoped. It is just saying that bodies accepting public investments or deposits would typically be required. So I don't know whether we could get a bit more assurance. That's on page 8, the last reply there. It's just in terms of the ensuring that lessons have been learned. It does sound like it's not compulsory.
Well,
and that's just a slight concern I have.
I think it's worth saying just on this. I may be wrong, but my understanding of this is that this. So I think the implication here is that, first of all, that obviously this happened before lots of the post-crash legislation happened, and I think even before the I think the Presbyterian Mutual Society got into bother and difficulties before the existence of the FCA. The FCA was created.
I think it was pre-FCA, Chair.
So and that was in the.
I think they could still have been registered with it.
Well, it couldn't have been registered with the FCA because the FCA didn't exist. It was the
Compensation
FSA.
Authority.
It was the FSA. So I think what they're saying is basically this was if a version of this happened now, they would. But I mean, I'm happy to go back and just clarify that point. It was obviously, it's worth saying this is in one sense reserved. It was that this was a particular issue to just obviously a specific group of people in Northern Ireland, and that's why the then executive effectively did a joint loan, and I think they asked for the RRI, the borrowing headroom, to be increased in order to give the loan. So it was effectively they got additional borrowing power from London to meet their share of the loan. I mean, we can just ask the question: are you confident this wouldn't happen? If that would help for you, Brian.
Just to know, has any audit been done? And I don't know how many institutions are like that locally. But I would like something a bit firmer, just to know, because that ended up that almost the public purse was having to bail them out.
Yeah, well,
because they hadn't registered in what was essentially the insurance scheme for their investors.
Yeah, so I suppose mean, the use of the word investment is a bit interesting there, because it implies that the money lent by the Northern Ireland Executive at the time was an investment. Clearly it was an investment which basically instantly became worthless, because it was about making sure the policyholders were protected rather than taking a stake in a going concern which would have some value on the balance sheet, because it doesn't.
Well, I think it refers to their investors who are putting money in. Whilst they weren't a bank, they're still a public investment scheme that people
That's
were,
true.
were paying into.
You're right. You read that better than I have, and that you're right, Ryan. But I think the point still stands that basically this is pre. I mean,
well, my question, Chair, sorry to
yeah.
interrupt, is has an audit been done, of any locally registered groups to ensure that they are properly registered?
I'm happy to answer. The types of organisations locally that would be, I think, accepting deposits or in this way, or investments as they're called, just use the word investments are things like existing mutuals, and there are still some small mutuals that exist, credit unions. There are only a couple of building societies, obviously, which exist in Northern Ireland. If they could just, if they want to just, if they could, I guess we can ask them to give us insurance that they are reassured that all of the local organisations. But it's worth saying that this wouldn't be a policy area for us. This would still be for the FCA and, as it were, London. But we can ask that question.
Yeah, just in terms of so that lessons are learned, and all it's done to prevent it happening again.
Yeah, so I think that's for an audit of continuing liability, Chair.
Yes. Well, okay. Yeah.
We should have done something about
yes.
that.
Okay. Fair enough. Okay. Grand. That's that. We are then going to move on to 5.6, which is a Dallo readout of other items. It begins with so the first one is a response to a question that we asked quite some time ago, which is around the arm's length body review. So way back, and I think lots of the committee wasn't in Stormont at this point, but I was, even though I'm still a young, fresh-faced MLA. There was an agreement at New Decade New Approach to do a review of arm's length bodies. We asked what status there was on the arm's length body review. The department has indicated that so the department indicates it commenced a new exercise. So that began and then it stopped in 2022 when the institution, after the election, the institution was collapsed. The department indicates that it commenced a new exercise with departments in September 2025 to assess the statement of departmental reviews, their conclusions, and the priority ministers are giving to ALB reform. The Department of Finance anticipates completion of this exercise in early 2026. I have to say I find this answer a wee bit demoralising because it kind of indicates a bit of the cycle of endless reviews and with no apparent direction at times, it would appear. It would be helpful if the department could just tell us whether this review of arm's length bodies is still live, in the sense that if this is the thing that was agreed in 2020, or if it's just a bit of a dead letter and they kind of began an exercise again after we had asked them. By the way, we first asked this question on the 30th of April 2025. They then went and commenced a new exercise in terms of information gathering in September 2025. So did they only restart this exercise because we asked the question? And what's the actual upshot of it? It's just a wee bit demoralising. But anyway, Deputy Chair.
Yeah, thank you, Chair. And this is one I feel quite strongly about as well, especially as we're looking for public sector transformation and efficiencies. And I wonder, is it something that perhaps looking back to even our inquiry, if there is any scope to look at that in terms of the wider shared service? Because again, we see this continuous establishment of new NDPBs, new commissioners' offices, and every single one of them, there's a few £1 million in terms of back office administration for every single body that is formed. So I raised this on the floor with the Finance Minister before, and he agreed with me that it is time for that fundamental review, where if we're looking for efficiencies, this really is critical right now in the budget that we're facing. So the two sides to that. One, I wonder, is it something we can touch on in the backdrop to our inquiry? I don't know how much insight we have to that, because obviously they're 1 degree removed in terms of that detachment piece, but I definitely think that we should be considering in terms of our centralised role, even writing to other committees to say, Department of Finance only has an oversight here, but this is clearly a priority. Is your department doing this? Where are they with that? And maybe that would give it a little bit more weight.
I think that's fair enough, and I think, in one sense, it's a priority. We don't really know if it's a priority because they've asked, and they've asked the question: is this a priority? Their response to us is they've written to other departments to ask for the priority that the current ministers, i.e. others, are giving to ALB reform. I think that would suggest that there is an agreed policy, but I think that's fair enough that we ask the question. So yes, I think we should write to other committees and take a bit of a grip on it in terms of how it fits in. Certainly with the civil service stuff, we may be able to gather some information about how many civil servants are in arm's length bodies, because they will all be NICS employees, I would think. So yes.
No, Chair. That's where things become more complicated.
Right.
A number of years ago, it's not unlike the Assembly itself. A number of staff here were effectively seconded and were offered the decision a number of years ago now whether they wanted to remain here and effectively become direct recruits, or whether they wanted to return back to their departments. A similar exercise happened with Invest NI. I think with Tourism NI, where staff could either go back to parent departments or stay where they were. So they are not NICS as we here in the Assembly aren't.
Okay.
So we can check with the other committees.
Okay.
I think some departments did actually complete the reviews. I want to say that's the case. So we'll check back anyway.
I think the Deputy Chair's recommendation is a good one. We just write to the committees, and I think because this answer is just so kind of it's a wee bit surreal.
We do this. We go to Scherie.
Great. Okay. So next, the next discussion session. So we'll go straight to Scherie again. Okay. So we're now going to go straight to our evidence session, members, which is
number
agenda item 9, which is on page 667 of the meeting pack. There's a clerk's memo at page 667. There's also the OECD submission and the submission to the call for evidence in the bill, which is at page 671 and includes their very helpful traffic light recommendation. And then on page 688 is the department's response to the OECD submission and previous information provided by the department on independence of the proposed or the independence of the Fiscal Council in its legislation and how its budget set at page 692. So we're going to get an oral briefing on Zoom from Scherie Nicol. Hi Scherie, thank you very much. Scherie is from Sherie's the lead on independent fiscal institutions. We really appreciate her joining us, and indeed the response, the very detailed response we had from the OECD. So Scherie is the lead on independent fiscal institutions, as I said, in the Public Management and Budgeting Division, which is inside the Directorate for Public Governance at the OECD. I should just say before we begin with Scherie, she has indicated, just given the constraints around the OECD's role, she's participating exclusively in an official capacity. Her participation is obviously not a waiver of the privileges of the OECD, which is an international organisation, and she won't be able to answer any questions which doesn't pertain to the work of the OECD. So important to put those on the record. But nevertheless, and also I should say, won't be answering questions on confidential information. But I've set all those out, and I'm sure our members won't be asking those questions in any case. But thank you very much, Scherie. If you are able to give us an opening statement summarising your view on this bill and the evidence that you've provided to us, that would be really helpful. I assume you can hear me?
I don't think she can.
Yes, she can. Wait a moment or two. Let us know when you're able. Okay. Yeah. Correspondent broadcasting.
We are just going down to doing that now, Chair. We have a Teams link to them.
Hello?
That's
Can you hear me?
Great. Can you hear me?
Yeah.
Sorry, were you waiting for me? I was
Only for a moment or two. Thank you very much for joining us. So I don't know if you heard, I give an introduction to.
sorry, I didn't hear it.
No problem. Well, I mean, I won't go over it again, but we did outline just given the OECD's roles in international organisation, some of the context and constraints or indeed or caveats in terms of your evidence, the independence of the OECD and your speaking and the context in which you speak. But can I thank you first of all for joining us today and for the written evidence that you provided for us, which has been most helpful for the committee and I'm sure will be helpful for our Assembly more broadly in terms of considering this legislation. Obviously, as you'll be aware, the Fiscal Council has been in existence since 2020 when it was agreed as part of a political agreement that restarted our institutions at that stage. It has existed, I think, largely successfully and has built public trust. But obviously, it's thankfully getting onto a legal statutory basis. And as the kind of gold standard experts on independent fiscal institutions, we really appreciate the OECD's giving us their views. If you're able, we'd really welcome an opening statement. Feel free to summarise your perspective on our bill and indeed your work on IFIs more generally.
Thank you very much, and thank you very much for welcoming me to give evidence on the Northern Ireland Fiscal Council Bill. We're delighted to be here because we've actually got a long experience working with member countries across the OECD in designing effective independent fiscal institutions, guided, of course, by the OECD Principles for Independent Fiscal Institutions, published in 2014. And these set out the global standards for independence, mandate, resources, and transparency of these institutions. The role of fiscal councils is becoming even more critical in today's context. Across OECD countries, governments are facing unprecedented challenges and budget pressures, from aging populations and rising health costs to the climate transition and defence spending. These challenges are demanding rigorous and independent scrutiny of public finances, and Northern Ireland is not immune from these pressures. The Fiscal Council in Ireland plays a crucial role in empowering both public and political understanding and debate of these long-term fiscal pressures, helping to ensure an informed debate and more sustainable decision-making. Turning to the bill itself, it has many strengths. I can highlight a few of them. We are happy to see that there are clear statutory functions set out in the bill with strong provisions, granting it clearly defined responsibilities and autonomy in setting its own work programme. We're also delighted to see strong transparency provisions, for example, mandatory publication of all of its reports, which will help build trust and credibility. Access to information is another area of strength. The bill provides a statutory right of access to government data, which is essential for effective scrutiny, as well as external evaluation. The requirement for periodic independent reviews is a positive feature that will really help maintain the standards and relevance of the Council over time. Of course, as with any legislation, there is room for improvement, particularly to align more closely with the OECD principles and strengthen its impact and trust. I would like to highlight 3 areas where I feel the bill could closer align with OECD principles. Firstly, the appointment of leaders. The bill, as it's currently drafted, doesn't contain explicit safeguards to ensure the appointments are made of a non-partisan and merit basis. And although we do know that the appointments will be in line with the Code of Practice and the Commission for Public Appointments, a secondary document, these merit-based criteria are not inside the legislation itself, providing more meaningful protection against politicisation. And the absence of this risks undermining that appointment process and opens the door to potential political influence. There's ways to strengthen this, for example, either including qualifications for members within the legislation itself, as is the case in many pieces of enabling legislation for fiscal councils. That would be, for example, expertise in economics, public finance, and familiarity with the budget process. Another option could also be introducing a secondary approval mechanism, such as review of the appointment by a parliamentary budget committee to reinforce a non-partisan appointment process. Secondly, an operational autonomy. There are some areas where the council's operational autonomy is somewhat constrained under the current draft. For example, while the council can employ staff, the terms are subject to approval by the Department of Finance. This really limits the council's ability to independently manage its human resources, which is essential for maintaining its impartiality and responsiveness. And experience in OECD countries has shown that this can be used as a vehicle to constrain operations of these institutions. And I think that is something that could be reconsidered to safeguard the council's ability to conduct its mandate. Financial independence is similarly compromised, where at the moment the council's running costs are included in the department's overall estimates rather than being a distinct budget line. Not having a distinct budget line means that the council is more vulnerable to political pressures. So we would recommend having that separated out so that any reduction in its budget can be clearly identified in the annual budget process. Another way of providing protections is by having multi-year funding commitments, as we see in other independent fiscal institutions, and that would provide stability and reduce the risk of political pressure. Lastly, stakeholder engagement, including parliamentary engagement. The bill at the moment doesn't provide a formal mechanism for the council to engage with Parliament or the public, and there's no provision for responding to requests for analysis from assembly committees or individual members, nor for broader engagement with stakeholders such as media or civil society. Embedding these responsibilities in the legislation could enhance the council's relevance, support parliamentary scrutiny, and promote fiscal transparency. I guess overall, it's clear that the legislation was developed with OECD principles for independent fiscal institutions in mind, which we're happy to see. However, there are elements of the bill that rely on external processes and non-legislated practices to maintain adherence to these principles in a number of areas, from merit-based appointments to operational autonomy. A concern here is that while these practices may appear solid now, without formal legislative backing, they could remain vulnerable in a different context. And recent experience across OECD countries has shown how quickly established practices can change when circumstances shift. I welcome the opportunity to discuss these points and others in more detail with you today.
Thank you very much. Scherie, our broadcasting colleagues are watching. Yeah, I think echo there has stopped. There was a little bit of an echo at our line. That was really comprehensive. Thank you, members. As always, indicate for the purposes of answering questions. Just first of all, you mentioned there at the end of your statement about the drift in some independent fiscal institutions from what were called established practice, i.e., I presume by that you mean custom and practice that is not mandated in legislation, away from that in certain contexts in a way that I presume you found worrying. Are there a couple of specific examples you could give the committee of where that's happened, where specific important things aren't set down in law and then but they're only, as it were, convention, and then the convention is for one reason or another undermined or ended?
Yeah, I guess one of the examples that would be easy to highlight to you would be from Argentina, where the Parliamentary Budget Office has the budget and the legal ability to hire a number of staff, but has to get, for example, approval from the committee in Parliament in order to do that. And I think at the time that that legislation was put forward, it was envisaged that that would, not necessarily be a stumbling block to hiring at the Parliamentary Budget Office, but actually, in reality, it has become a big stumbling block, and they are very constrained in their ability to fulfill their mandate because they are not able to get the parliamentary approval for the staffing that they are legislated to have. And so what you really see here is processes that were envisaged to act quite smoothly at the time of legislation, but where political circumstances have really brought about a change that is not actually working in practice. And we've seen other examples, for example, in Canada, where an initial budget was promised but not delivered on later on when, for example, the Canadian Parliamentary Budget Office published a report early in its institution, which was particularly badly received by the government at the time, and the initial budget that had been promised was not delivered later on because of the extent to which they were unhappy with the hard-hitting assessment of the institution in its early days. So you see that, where practices are not actually embedded in the legislation, but come through, other processes that are seen to be, well, there's no reason why that wouldn't operate smoothly. Well, actually, there's plenty of reasons why it could begin to not operate smoothly if the political circumstances change.
Okay, that's helpful. And I guess further to that, obviously one of the reservations you have expressed about the bill, which you've given a welcome to in many other areas, or you've not endorsed, it's not for the OECD to endorse, but you have said is broadly compliant with the IFI recommendations. But one area where there are some reservations is around operational autonomy and specifically recruitment. Just to be clear, is it you just might want to say a bit more about that. You mentioned it in your opening remarks, but you are, for example, one worry might be that any doubt upon the council's ability to recruit on its own terms would sort of almost instantly really compromise the independence. And is it that the person is then there's a possible chill effect on the person whose day job is still kind of, as it were, overseen by the host department? Just if you could set out some of those concerns in a bit more detail.
Yeah, I swapped to another microphone, so let me know if there's any problems hearing me.
It's fine.
But great. So essentially, I think what our concerns are around hiring staff is that really the institution itself, the Fiscal Council, should have full autonomy when it comes to hiring staff and setting the conditions for those staff when it comes to, for example, salary and other employment conditions. And at the moment, the Department of Finance has a role in approving that. And I think that, that is something that would be abnormal to see in the OECD context. And I would worry about the extent to which that exposes the Council to, continuing good relations with the Department of Finance in order to have sustainable staffing. So I would like to see greater operational autonomy when it comes to the ability to hire staff and set the terms for its staff, so that it's got the confidence to undertake, hard-hitting work if it needs to, without the Department of Finance, being able to show retribution by, limiting its ability to hire staff or give them the terms that would enable it to function effectively.
What would so a lot of this is set out in the schedule of the bill. What if it's not too broad a question? What would good or better look like in your view?
I think for me, so this by the schedule of the bill, you mean so the actual bill itself. So I'm just moving to the membership and staff. Let me just move to the right section. So staff, 30. So for example, on page 8, paragraph 20, it says the Chief of Staff and other council staff are to be employed on such terms as the council, with the approval of the department, determines.
Okay.
I'm not sure, for example, why the department would need to approve those terms. That's something that would seem to unnecessarily constrain the autonomy of the Fiscal Council.
That's helpful. Just related to that, one of the points we've that has been raised is really around, I suppose, both the budget setting of who sets the budget effectively, and in broad terms, and again, correct me if this is wrong, in broad terms internationally there are two models. One is that the legislature sets the budget, like the Congressional Budget Office. Two is that the executive sets the budget. That's the OBR model, for example. Does the OECD have a specific preference for one of those over another, or is it just either is fine, but there have to be significant safeguards in both in terms of independence?
We don't have a preference,
okay.
is the honest answer. And actually, even the characterization that you give, okay, I think there's much more diversity in practice than that. So, for example, some institutions, I'm thinking about, Estonia, Austria, for example, are funded directly by the central bank. So that's, it's not necessarily a model that would work in the Northern Ireland context without a central bank, but, there's other countries like Portugal where, other institutions such as the audit body or and the central bank, have an oversight role. There's other countries like Ireland where it's actually the budget is set out in legislation rather than being the responsibility of either the government or the parliament. So I would say, first of all, there is a real variety of funding models out there. The most important thing for us is that there is a transparency on the institution's funding on an annual basis. So an individual budget line and that is set out in the annual budget. And also what we like to see is that the budgets are treated in the same manner as those of other independent bodies in the country, such as audit offices, to ensure their independence. And that, so you can think about the Northern Ireland context and how the budget, for example, for the audit body is set. And that is, the sort of autonomy and independence that we would like to see for the Fiscal Council.
You would rather it was more like an audit office, effectively, then, in terms of how it's okay. Now, one of the other points you make, well, we've kind of covered that, but is around on the question of forecasting. Am I right to say that you think there should be more forecasting power? Obviously, as you'll know, obviously this is a devolved region of the UK, and the large parts, or the overwhelming majority of resource here is not raised local. It is raised locally, but it's then given back. It's granted via the block grant. So the analysis is, and there's a limited amount of fiscal devolution, albeit there are some parties all parties have some degree of interest in fiscal devolution. Some are more committed to it and more prioritise it more than others here. In any case, do you think there should be more forecasting powers, whether that's economic or fiscal, given to the institution?
Okay, so I guess my starting point would be that the mandate and functions of the institution should be determined by the local context.
Yeah.
So the OECD does not advocate for standardized functions across these institutions, but that the institution provides functions that are helpful in strengthening oversight of public finances in the necessary country. So with that in mind, there's a number of considerations in the Northern Ireland context. Obviously, we do see that in fiscal councils, it is common for these institutions to undertake forecasts. 12 independent fiscal institutions across the OECD undertake independent forecasts, and 21 institutions assess the reasonableness of government forecasts. But these are, of course, institutions that are national rather than subnational. And I think that provides a different context for you in Northern Ireland. And so what you have to think about is, are there any economic or fiscal forecasts produced at present? If there are not, does that provide a gap in your ability to scrutinise the budget? If there are, do you have concerns about the independence and reasonableness of those forecasts in a way that potentially the Fiscal Council could help address? So those are the sorts of questions I would be asking in your shoes in order to determine whether or not it would be appropriate for the Northern Ireland Fiscal Council to have this function.
Okay, that's really helpful, Scherie, thank you. I'm now going to bring in others who've been waiting patiently. First, the Deputy Chair.
Thank you, Chair, and thanks very much, Scherie, for joining us today, and thanks for this detailed submission. It's really, really helpful to us because obviously sometimes you get quite into the detail of it and you have a lot of questions, but to see it coming from the outside with a lot of the same questions that some of us were raising is quite reassuring that we're in the right territory with our questions. I think that something that comes through quite strongly, we have this need that we have the independence of the Northern Ireland Fiscal Council, and it's new, and with the opportunity to learn lessons and set this quite strongly from the outset. But I think a lot of this comes through that here our Department of Finance is almost operating under three different functionalities. We've got it as the Department of Finance core business. It also operates here as our effective treasury function. And then also we've kind of got this element where it is the shared service for civil service like staff and recruitment. So there's almost like three strands. So I feel that in drafting this legislation that is clear in the heads of those within the Department of Finance that are drafting this, but it's actually not clear when you look at it blind and externally. And for you coming in and seeing that, where we're referring here to the department, I think that it's come through loud and clear from what you're saying and from my understanding of it that there needs to be a very clear definition. If they mean a different part of the department, this needs to be set out here, because to me, where they're talking about the department, they're just using the department, and I can see from reading it and knowing the workings of the department, they're meaning the department treasury, they're not meaning core departmental business. And I think that's what's given rise to a lot of the concerns. And as you say, it's really concerning that at face value it looks like you may have undue political influence, and this is not in any way what we want here. And so just to kind of tease that out, where I'm saying that the department here has the business of the treasury functionality, do you think that if aspects of this in terms of approving remuneration and budget was set out, that it was the department in its treasury function that is approving that, would that be sufficient, or should it still be, in your opinion, someone external like the Assembly or a committee of this Assembly?
Thank you for clarifying that. It's not something I was actually aware of in the Northern Ireland context. I would say even, even if the bill specified that it was a particular part of the Ministry of Finance, Department of Finance, I would still have concerns, largely because I assume that these parts of the department sit under the same minister. And so if it's the ultimate decision of the minister, in relation to these different aspects, it wouldn't be necessarily unheard of or unsurprising if, concerns, for example, in one aspect of the Department of Finance ended up overriding a decision in another part of the Department of Finance, and feeding into the overall decision made by the Minister of Finance in a particular area. So I think that is something that would ultimately still concern me. So that would be my first comment. And my second comment would be, secondary approval is helpful not just from an independence perspective, but also from a buy-in perspective. And this is something that we witnessed in Scotland. I think that the people who gave evidence to you from the Scottish Fiscal Commission mentioned this as well. But when the Budget Committee at Parliament has skin in the game and has the secondary approval of the leadership, for example, it means that they are bought into the leadership choice, and that helps the institution have impact in Parliament. So I guess, what I'm trying to say is, even if you didn't doubt that the Department of Finance would ever have any ulterior objectives, there's still benefits for the impact of the institution of having secondary approval in place for the leadership appointments and other aspects.
Yeah, absolutely. And on both sides of it, it gives effectively a minister a bit of cover, because if the Fiscal Council are bringing an idea that's to be mooted, some ministers wouldn't maybe want to approve that it goes ahead, because it makes it look like they are bought into a particular political decision in and around charging or taxation or anything that it may be. So I really appreciate your comments on that. I'd be very keen, we raised it before about these appointments needing to be merit based and focusing on that, so that it is on status alone. It's not on who has been hand-picked for a particular reason to do this job with a particular view of the economy or just the economic position here or the politics of it. I'd be very keen that it is merit-based. But do you think, would it be the norm that you would expect the ins and outs of that merit-based recruitment process to be on the face of the legislation?
So it's interesting that you ask this, because I looked back at our assessment for the Scottish Fiscal Commission appointment process, which is quite similar actually to the one proposed for the Northern Ireland Fiscal Council. And I realised that I'd been inconsistent in my assessments of the Northern Ireland Fiscal Council Bill and the Scottish Fiscal Commission. And I tried to understand where that inconsistency had come from, right? Because essentially what I'd said is that the appointment process in Scotland was a strongly independent process, and I'd said in Northern Ireland it wasn't. And then when I realised that actually the Scottish process had a secondary approval in place, that's when I realised that that's what gave the guardrails to the fact that there wasn't actually the qualifications set out in the legislation in Scotland. So I really think it, at least has to be one or the other, right? It either has to be that the qualifications are set out in legislation, and that is something that is very common across OECD countries. Examples of councils, for example, Ireland, the legislation says that the candidate has to have competence and experience in domestic or international macroeconomic or fiscal matters. For example, the Slovenia Fiscal Council says that members shall be experts in the field of macroeconomics, public finance, or budget management. And this is actually in the legislation itself. I understand with the UK OBR and the Scottish Fiscal Commission and the Northern Ireland Fiscal Council, there's more of this UK model whereby this sort of public code of conduct is lent on as something that works quite well and is merit-based, and thus the qualifications don't necessarily need to be set out in legislation, but that does differ from international practice. And I think, you know, that's why it raises concerns to me. And if you also do not have that secondary approval in Parliament, then, you know, then it does unfortunately raise concerns for me. So I think, you know, at least one or the other.
Thank you very much.
Okay.
Brian.
Brian Kingston. Brian.
Okay, thank you. Thank you, Scherie, for your paper and attending online today. Yeah, we did have a useful session with the Scottish Fiscal Council representatives. They told us, if I look at my notes, that they had an open and fair competition for the appointment of their commissioner. I mean, the kindest thing you could say about our bill is that it's enabling powers and is a bit short on detail as to how things will happen. It just says that the department will appoint members. I note in the schedule there's a page and a half on how people can be dismissed or resign from it, but there's one line on how they can be appointed. So they actually have that recruitment, open recruitment exercise for their members, and they said they have a range of other legislation which applies to how people are appointed. So you've highlighted that as a weakness. I think you called it room for improvement. But in terms of what does exist, I think you referenced something that does exist regarding public appointments that would apply, because they said they had other more detailed rules about public appointments. In terms of what would apply in our case, I know I should know that from our end of things, but are you saying what restrictions do exist around the appointment, or is it purely in the hands effectively of the minister as things stand?
I mean, my understanding is that appointments will have to comply with the, the public appointment code of conduct, or I'm not sure of the formal name for it, but that this has functioned, I mean, relatively well in, for example, Scotland so far. But I guess overall, what I would say is there's several areas in this bill, not just the appointment process, where the bill is light on detail because it says that there's another, document where more specific aspects are set out. And I think that overall, that gives weakness because, if those provisions are not actually legislated for in the bill, but are instead reliant on, public sector practices, then it does give a vulnerability to those practices continuing under different government arrangements. And so it's really a call that you have to make. And I would say that across OECD countries, we are seeing, the political situations that are quite volatile compared to in the past. And these institutions are going to be put under increasing pressure as the budget becomes central to debate in coming years, with aging, putting so much pressure on public budgets. And the messages from these councils are going to be quite difficult for governments to hear. And they're going to be in the crossfire in a way that they haven't been in the past. And so, if I was sitting in your shoes, I would be thinking about, not necessarily how have these arrangements worked in the past in other countries like Scotland, but thinking, how can we ensure that no matter what the political situation in the future, we can ensure that this institution is independent and autonomous. And I think that the best way to do that is having detailed provisions actually in the legislation itself.
Yeah. No, it's clearly something we will have to give more attention to. Again, it's just otherwise everything's in, there's the gift of it being too cosy a relationship, and if the minister has the power to appoint and dismiss people, it takes away from the independence of the council. But my last question, just, I mean, how would you describe how the relationship between the Assembly, the Executive and the Fiscal Council should be, and in particular the Department and the Minister? I mean, obviously it's a challenge role, it's a scrutiny role, or they won't have any statutory powers as such, but is their role just to be critical, to examine? How would you describe it?
Yeah. So, I mean, it's kind of a little bit of, it's not as simple as, describing it, I guess, in one word. In many ways, these fiscal councils are actually incredible resources for departments of finance, right? And I say that because the departments of finance are dealing with really compelling budget demands from a range of institutions across government, and having an institution that is echoing their concerns with other departments that, the budget is tight, that, for example, there are pressures in some areas that are coming that mean it's going to be difficult to maintain spending in other areas. And that's actually, helpful for the Department of Finance in exercising its function of dealing with all the different budget requests that it gets for departments. So they can be very helpful for Department of Finance. But of course, where the Department of Finance isn't necessarily making decisions that are in the short or long-term interests of citizens, these also need to be highlighted. And, there's the classic example of pre-election budgets, where there are giveaways and decisions made that would not necessarily be made at other times. And these need to be called out by independent institutions, and as do other decisions that are not that go against the interests of citizens in the short and the long term. And so those messages will be difficult for a Department of Finance to hear who is under political pressure. So that's why I say it's not like, they're not going to love them, they're not going to hate them, they're probably going to love and hate them in equal measures, right? And that's what you would want to see in a healthy, functioning democracy.
Okay, thank you. That's great. Thank you, Chair.
Okay, and then we've no one else. A couple of just final points from me, Scherie, before we thank you and bid you farewell, is in relation to specific requests from the legislature. So the bill is relatively, it obviously sets out budget assessment reports and fiscal sustainability reports as things that it may that it has to publish, and it has to lay them. I think I'm not sure whether it's in the main bill or the schedule. Yes, it says under its main functions that the bills, that the budget assessment and fiscal sustainability reports are to be laid before the Assembly. But other than that, it isn't that specific about the rights of the Assembly, including, of course, this committee. Do you think, are there things that might specifically be included in the face of the bill in terms of rights of request, or and that this is separate to the kind of budget reporting line and as it were, line management or ownership question, but this is about its reporting line as a reporting body to the Assembly as well as to the public and the department? Could we include more? What kinds of things might we think about including in there?
Yeah, so I mean, just to give an example of provisions that exist in other countries, I mentioned Slovenia earlier. The Fiscal Rule Act in Slovenia mandates ongoing parliamentary engagement by the Fiscal Council, and this includes specifically regular presentations and discussions in the National Assembly on fiscal policy planning and implementation. Other countries actually have it in legislation that the council has to appear before the legislature at certain times of the year. So, for example, in Chile, the Autonomous Fiscal Council has to appear in the months of May and October each year before the Joint Budget Committee for formal reporting to Parliament. And there's also some areas where the councils also are mandated to require to respond to requests from the committees or from members themselves. So I think that's at least worth considering whether there is, something in place that promotes regular Parliament engagement, and B, would you want to specify a set number of appearances before the Budget Committee each year, or tie them at least to budgetary events? And then lastly, what would you want ideally in terms of how the council responds to requests from committees and members? And at least having thought that through as part of the process of looking at this bill.
Okay, that's really helpful.
So just to supplement that, for example, the Canadian Parliamentary Budget Office takes requests from certain committees to prepare research reports on legislative costings. So, these are the sorts of type of work that these institutions can be asked to do by committees.
Okay. One final one from me is just in relation to the question of independence. The response we have from the department, I'm not sure if Scherie, we did send it to you. As it were, the burden of their response rests on a mixture of Cabinet Office guidance and managing public money, which is a Northern Ireland devolved document, which, in a sense, they are adhering to guidance which relates to arm's length bodies in general, rather than, I suppose, specifically watchdogs. And I know watchdog is not a term probably that the OECD would endorse or use, but for the purposes of the vernacular, this kind of has a watchdog function, which is different from a function that is to be done at arm's length, but not necessarily whose primary function is scrutiny. Would you accept their, so as I say, whenever it comes to the question of independence, they've come back to us and said, basically, this is consistent with how arm's length bodies are done, i.e. they are non-departmental public bodies rather than non-ministerial departments. Those are kind of very UK terms, but you'll understand, I'm sure because of your experience, you'll understand the distinction. Would you, I don't want it to come out and ask, do you buy that, but do you buy that?
I guess it goes back to what I was saying in relation to the leadership appointments, yeah. Right? In that there's certain elements of the independence of this institution that are reliant on, guidance documents that exist outside the legislation. And while these may have worked sufficiently in the past, there is always the possibility that they do not work sufficiently in the future, right? And political contexts can change. So, the strongest way to guarantee the independence of the institution is to put those aspects in the legislation of that institution.
Okay, that's very clear. Thank you very much. No one else has indicated any questions at this point. So we're going to say thank you very much at this point, Scherie. That was extremely helpful, comprehensive evidence, and I think we've all benefited from it. So can I put on the record our thanks for that? Thank you. And we may be in touch with you again because you've proven such a helpful evidence giver. Thank you.
Thank you very much.
Okay. members, can I just suggest that we, in addition to the other information that we send to the Irish Fiscal Advisory Council, that we send the written
Chair,
briefing
Sherie's
Sherie's
paper, the department's response and the Hansard of today's session,
That'll
it just gives them the context, Chair, of
just to give them more information to
plus the examples that Scherie has given, because she did the review of the Irish Fiscal Advisory Council. So it'll just allow them to pick up on some of those issues specifically, and it makes it a bit easier for them to shape their evidence.
Members are content. We'll do that.
Thank you.
Okay. So, now members, we are now going to go into agenda item 10. There's a, we're not going to go, we may go back and do our closed session discussion on some bill stuff, but we're before that going to go to agenda item 10, which is relates to the consultation on divorce law. That's at page 27 of the table pack. There's a briefing paper there from the department. It wasn't provided in time for the main meeting pack. The officials are here to give us an update on the outcome of a public consultation on proposed reforms to divorce and the dissolution of partnerships. The department points out in its briefing paper that during the initial 10 weeks of consultation, the majority of online correspondence, which is 90% after the first 4 weeks, expressed support for change, typically favouring a move to a no-fault divorce. However, in September there was a notable increase in opposition to reform, which resulted in the final outcome whereby around 2/3 of online respondents were opposed to change, generally on socially conservative grounds. A similar pattern was observed when there was a 2018 divorce law referendum in England and Wales, which both in the end proceeded with reform. In any case, officials can reflect on those responses now. We're very pleased to have Michael Foster, who's Head of Civil Law Reform, Martin Tyrrell, who's Policy Advisor on Civil Law Reform, as is Maurice Dowling. Thank you all for joining us. Michael, do you want to give us an opening statement?
Sure. Thank you, Chair. So, I mean, you'll know that this work had its genesis in a motion last year in the Assembly, which called for the Minister of Finance to reform our current divorce laws to bring it into line with a no divorce system. Yep. And that was agreed to by the Assembly.
No fault divorce system, I should say.
Sorry?
A no fault divorce system?
Sorry, yes.
Not quite a no divorce system.
A no fault divorce system, yes. And after that, our team did some work on it and invited a range of interested stakeholders to meet with us to determine the range of issues in order for us to design a public consultation. And those meetings took place late last year and into this year. Were very constructive and helpful. Following on from that, we then obviously prepared the consultation document, which was issued in June, and it had a closing date for responses at the end of September. We received a total of 405 responses to that consultation. So for the last number of weeks, we've been considering the results of the consultation, and those, Chair, are set out in the briefing paper. I don't propose to go over them in detail, but perhaps instead highlight just a few key points. First, as you've already outlined in your opening comments, support for change in the law was in a minority of the 405 responses we received. We felt that was perhaps surprising, given the level of support that seemed to be prevalent in the Assembly. But on the other hand, based on the similar exercise which you referred to in England and Wales prior to the change in the law there, it was perhaps to be expected. So around 64-65% of consultees have indicated they favour no change to the current law.
Sorry, could you remind us how many responses there were in total?
405.
405, okay.
Yeah. And as you mentioned as well, Chair, it is perhaps worth noting that until the final 2 weeks of the consultation, there had been a significant majority in favour of reform, but in the last 2 weeks of the exercise, those numbers flip-flopped. Secondly, it's probably worth pointing out that there were others who responded who did favour reform, but stopped short of seeking a no-fault system. That category of respondents includes some fairly key players in this area, including the legal professions, Women's Aid, the Lord Chief Justice's office, or Lady Chief Justice's office.
Those groups said they favoured reform, but
not fully no-fault divorce. Yes, and they weren't alone in that. There were others who outlined similar. I've highlighted a number of them.
We'll come on to ask about that. Okay.
Okay. So in total, around 70% of consultees did not favour a fully no-fault system, although 80% of the respondents then went on to suggest that fault should be retained in some shape or form.
80% of the
felt that fault grounds should be retained in some shape or form. So the paper we have submitted today to the committee seeks to summarise in a fairly brief way the views of the groups that responded. And it's worth noting out that in England and Wales, some 83% of respondents were not in favour of change. But it was also the case that in that jurisdiction there was a high-profile campaign during the consultation on behalf of the No lobby, and we didn't see any particular evidence of that during our consultation period, although it is obviously noteworthy that in the last couple of weeks there were a significant number of responses received that were very similar in terms of their the points that were being made. Briefly, the main reasons for opposition were grounded in views that marriage is a divinely ordained institution, a foundational society contract, and its integrity should be preserved in the public interest.
And it's important to say the law does not say it's divine. The law does not have a view on whether it's divine or not. The law, if people are married under the civil law, they're married by the civil law, not by a divine body. Yeah. That's correct.
Those were some of the themes I think that were drawn out from those who were not in favour of reform. And the general concern was that by making divorce easier, we jeopardise marriage and the family. Okay. Those in favour of change tended to offer more direct observations of their experience, knowledge and understanding of the current divorce system, noting concerns like the burdens associated with the lengthy separation periods that are required in this jurisdiction, the use of fault grounds as a means of coercive control in abusive relationships, and the accessibility of the current system. Those were the key sort of themes in favour of reform. But it is worth noting that those in favour of reform offered different views on how far reform should go, from fully no-fault divorce to shorter separation changes and periods, and then others who advocated just minor changes to the current law. So, as things stand, Chair, we have briefed the Minister and we met with him on Monday. He has noted the headlines from the consultation and has indicated that he'd be interested in the further qualitative work that we are aiming to complete quite soon, that will provide a little bit more detail and context. He's also asked us to clarify some points raised in the consultation with certain key stakeholders, and we are currently undertaking that piece of work. But he is keen to make progress on this policy area, ideally during this mandate, and we anticipate that we'll have a much clearer idea of his preferred approach over the next few weeks, and as we complete this additional work that we're undertaking now.
Okay, so just for the purposes of the record, it's worth saying, our divorce law was not I presume is not exactly the same, but largely the same as what it was in England and Wales pre-reform.
It's exactly the same.
It was exactly the same.
And for all intents and purposes.
For all intents and purposes, exactly the same. Okay, meaning that for a decree of whatever it's called, for the formal decree of divorce to be issued, someone has to be an acknowledgement of effectively blame legally. Or there has to be a process that gets to that happening, or explain.
No, under our current law, there are 5 routes. Actually, well, the headline route is that there is an irretrievable breakdown of the marriage.
Yes.
But of that, there are 5 facts, one of which or more need to be proven in front of a court. One is desertion, which is rarely, if ever, used as a ground for divorce.
Okay.
The second is adultery, which is used in some cases. The third is unreasonable behaviour. Okay. Those are the 3 fault grounds. Yeah. But on top of that, then, without having to establish fault, if parties have been separated for a period of 2 years and they both consent, then that is one of the factual grounds that can be used. And then the final one is 5 years separation without consent. And that, in many ways, was the genesis for the reform in England and Wales, because there was a very high-profile case of Owens v. Owens, in which a couple, fairly elderly couple who had been married for many years, the wife basically said she didn't want to be with the husband anymore, but he didn't agree, and she couldn't establish in front of the court that there'd been any unreasonable behaviour. She simply didn't want to be married to him anymore.
Yeah.
But because he didn't consent to a divorce, she would have had to have waited the full 5 years because she couldn't establish any fault grounds. And that's why the law in that jurisdiction, that was the spark for the change in the law in that jurisdiction.
Okay. So those are the grounds on which, and the reform in Wales means basically it can happen without a mandatory separation period, or just basically.
Yes and no. There is now what is determined to be a period of reflection.
Okay.
So but it's a much more straightforward process now. You can make a sole application or a joint application. It's fully online, and after a period of a total of 26 weeks, you can be effectively divorced.
Okay.
Without having to go to court, without having to establish fault, and there's no mechanism in which the other party can respond to the proceedings.
Okay, so effectively, is it right to say that in order to, there has to be a court process in Northern Ireland for a divorce to happen? It has to go to a court at some point?
There does. At this stage, there is a provision within the Family Law Northern Ireland Order 1993 which can dispense oral testimony in certain cases, but it's been never brought into operation. So the net effect of that is that even if you have two parties who both consent to a divorce, there's no quibbles about children, property, or anything like that. One of the petitioners has to go to court and present their writ to the judge and run through their petition before the decree nisi can be granted.
And they can't do that without, they have to do 2 years, even if it would have to be a 2-year process basically for that to happen.
The exception to that is, of course, if there is fault proven. If there's unreasonable behaviour, adultery or desertion, the 2-year separation period is not applicable, and a party can bring their case to the court without having that separation period.
Okay, so at the minute the minister, so the responses were the majority not in favour of any change, but important to say that it appears that there was a particular cohort of people who, I'm kind of speculating here, but who became aware of the consultation happening and submitted responses. We were saying, were the responses, and I don't think it's not illegitimate for these people to do this, by the way, but MLAs will be used to getting pro forma emails. Were these pro forma? Did they have the same words in them?
Well, these responses would have been on citizen space, so they'd have been online where a number of questions are asked and there are boxes in which to answer. So it's a pro forma already existed to an extent. Okay. The answers themselves, though, I think, and I'll defer to Martin and Maurice, who have been at the coalface of this, but they were strikingly similar in many respects. Would that be right to say?
Yeah, there were family resemblances between the responses.
Makes sense. Okay, that's helpful. But that doesn't make them illegitimate. People are entitled to have to respond in whatever way they want. Just in relation to those who responded, so you mentioned a couple of people who were, I suppose, in favour of partial reform. I'm not going as far as in Wales, if I'm understanding correctly. And the people you mentioned were the Lady Chief Justice.
Well, the Lady Chief Justice usually doesn't adopt a view on policy matters, but she referred to the work of the Family Justice Review, which was chaired by the then Mr. Justice Gillen, which brought forward a very robust set of recommendations for the family justice system. And in that, there were circumstances in which the report felt that having fault retained as a ground was important. And I'll give, if you wish, Chair, an example of that, which they cite quite commonly, and that is typically a woman who has suffered many years of abuse at the hands of an abusive partner, who wishes to have this abuse documented in a public hearing in front of a court. And that was a case where the Review of Criminal Justice, or Civil Justice and Family Justice felt that it was important that fault grounds were retained.
So have fault grounds been removed in England and Wales entirely then? Okay. So it's effectively what they're calling for is an option for somebody who wants to proceed down that route by saying, for example, unreasonable behaviour, they want that to be recorded in a legal document, and that might be an option for example, somebody who's been in an abusive relationship.
Well, to an extent, yes. it wouldn't be recorded in the legal document as such, but it would be an opportunity for the person to give their testimony in front of a court in a public way. Now, in England and Wales, there's been some discussion post the reforms, which haven't been operational for very long. They've really only been in place for a couple of years now, but there's some evidence to suggest that conduct and fault are actually being pushed down the road to the discussion around financial provisions and the property arrangements. And this is actually causing delay and additional costs in the system at that point, which is obviously something that we would want to avoid.
Just explain that to me. So,
so in other words, somebody who has been involved in a relationship in which there's been a considerable degree of fault, and no matter what system, I think, Chair, that we employ at the end of the day, you're never going to get rid of the human side of this.
Of course,
and there will always be that type of distress and discomfort for couples who are faced with those situations. But what they're finding in England and Wales is that instead of having the opportunity to air these in the divorce proceedings, they're trying to bring them up in relation to the financial settlement arrangements. In other words, when the court is hearing contested matters about property and the division of assets and all that sort of thing. And the ancillary relief system, as it's known, is not equipped and doesn't actually take account of conduct, except in very, very strictly defined circumstances. So in other words, where there's been financial abuse of considerable status, then that can be taken into account in the financial settlements arrangement. Like, for example, the example sometimes cited is somebody who's had a major gambling problem and has basically fleeced the other partner of a considerable amount of money. In those circumstances, that type of conduct can be taken into account in financial arrangements.
Right, okay. But the law previously didn't, the law has generally always separated out the fault aspect of the divorce from the ancillary, the kind of financial settlement part of it. And so what you're saying is basically it's even having, sort of, as it were, abolished fault from the main part of the divorce award, or the divorce settlement. It's being pushed down later on, or it's being
some evidence of that, Chair. I mean, I wouldn't want to go so far to say that it happens in every case, but there is. It appears to be happening more often than it maybe did in the past in the financial provisions. Okay,
that's helpful. And so, whereas the minister is now considering this, and will then, at some point, you will give him advice on how to proceed, or he will bring a paper to the executive, or?
I think we're at the stage where we are going to come back to the minister on some of the points that he raised on Monday. Okay. And at that point, we will get a clear steer as to how he wants to proceed with this, and we will start the preparation of policy paper for consideration by the executive.
Okay. Just in practical terms, obviously not presupposing any position by either the minister or the executive, would it be? I mean, theoretically, you could pass very quickly a decision. It would probably be. Is it realistic to expect this not to happen in this mandate, but this would be something for the future?
It's going to be difficult to, just in terms of the weight of legislation that's already in the legislative programme this year and in the next, and also, from a resource perspective, to really push that forward. But that's not to say it can't happen, and we stand ready to try to do what we can in order to bring that forward. Okay. And the minister doesn't have a closed mind in this. He is keen to hear additional information from other stakeholders, which we're going back to clarify a few points around some of the responses. And I think he wants to find a good landing zone for this that will bring forward a useful set of reform.
Okay. Bring in the Deputy Chair now.
Thank you, Chair, and thank you all for coming here to brief us on this. I just wanted to ask around, you were making the point about the timings of the responses to the consultations. Would it be unusual to have more responses in the last few weeks?
No.
Yeah.
Not at all. And that's why, we're not presupposing that this has been some sort of orchestrated campaign by one group or another. We will analyse and take into account those responses in exactly the same way that we do with the responses we received on the 26th of June when the consultation opened, when we got, a number of responses on day one. The consultation period was open for 16 weeks, and each and every one of those responses during that time frame will get equal weight, if you like.
Yeah, no, thank you, because that would be my experience as well. And I know sometimes when I'm profiling in my own work, you know when it's due, and you'd be more
Absolutely.
inclined to do the work, build it up, and put it in closer to the deadline, be it replying to a consultation, applying for a job, or whatever it would happen to be. And I think with this one as well, it being open from June through to September, like there was
Over the summer, I
recess, it
agree.
was the summer holidays, and it wouldn't be unusual to see an influx of responses in September.
No, not at all. And we were expecting it. In fact, arguably, we expected to receive more in the last couple of weeks. And in fact, we ended up giving an extension of 2 weeks to some very key stakeholders who indicated that they'd welcome an extra short amount of time to finalise their response.
Yeah, no, thank you. No, just important to make the point that no matter what the pattern of it is, you know, all the responses are in, whether, you know, we like the responses, whether the minister likes them, whether, you know, anyone likes them, the numbers are there. And I was going to ask, although I think you kind of addressed it to the chair, what the next steps are and what we would expect to see in terms of the timeline, because it's my understanding the marriage law will be coming forward ahead of this, so I don't know what the timing would be on the both of those.
Well, certainly we would hope to have the marriage law to executive with a final bill before the end of this year. So we would expect it to come into the Assembly system early part of 2026. This work, if we do get a fair wind and we get agreement at the right time, we potentially could be looking at a bill in after the summertime next year, but it certainly wouldn't be any earlier than that, because we'd obviously have to take into account you know, resources across the whole piece, not just in our office.
Thank you very much. Thank you, Chair.
Okay, happy enough? Right.
Nobody else has indicated. Chair.
Nobody else has indicated they wish to come in. So thank you very much. I'm going to ask one, if I may, abuse my privilege as chair, to ask one final question. You published last year the same very hard-working team and under-resourced team in the department on the operation of the Defamation Act. I won't ask you to give me a detail, and then it was kind of the upshot was it's a bit too soon to tell. Is there if there's an update that you have, I think it would be helpful for us in written form to get that, just to keep an eye on that in terms of our post-legislative scrutiny. I won't ask you to go into it in detail now. Any particular?
Well, I mean, the frank answer, Chair, is that, you know, you're right. We are. I mean, you're effectively looking at the entirety of our team.
Exactly,
plus,
yeah.
You know, and both Martin and Maurice are part-time, as is Fidelma, who was left behind today to look after the shop, so to speak. And we simply haven't had the bandwidth to do any further work on this, other than we do keep an eye on developments in both here and the south and in other jurisdictions in these islands. But, I mean, it is, bear in mind, in England and Wales, when they reviewed their Defamation Act, which was in 2013 from memory, they didn't review that act for another 7 or 8 years to allow cases to get through. I mean, realistically, we're probably looking at the next mandate before we'd undertake any further work on that.
That's helpful. I would just ask if any patterns do emerge, I think it would be helpful for us to be kept abreast of them, but I wouldn't expect you to give me a kind of chapter and verse on it, because I do acknowledge that you're an under-resourced team doing a lot of work. But in the meantime, I'd say thank you very much to Michael, Maurice and Martin. He helpfully the 3 M's, as it were. I'm sure you've been called worse.
We have been called worse.
Okay, thanks very much.
Thanks.
Thank you.
Yeah. So members, appreciate we're now nearly at
This is an adjunct to item 6.
5 o'clock. We are going to seek agreement to something once I get moved to the correct page. Yeah.
We do agreement for that, and then I can talk on that one.
Fine. Okay. So members, we're just going to go back. What we're talking about now, we're going to go back to talk to agenda item 6, but we're not going to do all of agenda item 6. We're doing some of our committee deliberation on agenda item 6, which relates to our other current bill, the Administrative and Financial Provisions Bill. So we have written to other departments to kind of chivvy them along and remind them that they have very important things in this bill. Members will recall that the Economy Committee and Infrastructure Committee had submitted returns regarding their scrutiny of the clauses. So members, we want to get your agreement to schedule briefings from some officials from those departments. I'm going to get the clerk just to speak to it briefly.
Sure. So this is specific briefing for individual departments around their clauses that they've responded to through their various committees. So it would be useful to bring in officials from specific departments. I think there are some we'd already seek to bring in, for example, infrastructure officials around the Smart Pass. It would be useful to bring in education officials because the Education Minister has brought forward an amendment that expands out his clause on the bill, and there are various others. So if members are content, we can start putting in slots for that. And what we'll do is we'll bring a paper next week which will allow a final decision on just which of the departments we want to call up. But those would be the ones that we would be looking for first off. Others where a committee has taken extensive briefing, the committee might want to just take that briefing as is, but we can discuss that more fully. But it's really just to get that approval to start scheduling those briefings. And the other bit, Chair, would be in the pack at page 539. There's a raised paper on clause 18 of the Administrative and Financial Provisions Bill.
Clause 18 is the increase in the limit in the consolidated fund, which the Deputy Chair had in particular focus
so he's given us Nathan has given us a really good paper on that. And what I was going to say is, if members are agreeable, we'll get Nathan in to brief on that paper next week. And members are content, yep. So we'll do that, and then, Chair, if you want to move to, if we get agreement, Chair, if we can get agreement at this point to bring back any unfinished matters arising and correspondence to next week's meeting.
If members are agreed, well, I think we can still do some correspondence.
We'll try and do that as well. Yeah.
But if members are agreed, there's a few unfinished matters arising which we'll bring back next week. I'm just going to move now to correspondence, which is page 26 of my pack. Yes, thank you. So, agenda 11 is correspondence. We'll get through, I would hope, all of this. 11.1 is from the Youth Assembly, and it's their newsletter. That's at page 707, that's to note. 11.2 relates to the Brussels NI Executive Report. We've been copied into that, as we always are. That's at page 714 for information to note, unless anybody wishes to raise anything. 11.3 is from Land and Property Service and relates to the Trust Statement Rate Levy Accrual Accounts 24-25. Members, that's at page 751 of the pack. LPS has formally laid the 24-25 LPS Annual Report and Trust Statement, also known as the LPS Rate Levy Accruals Account. Whilst the CNAG has not qualified her opinion on the Trust Statement, she does have concerns regarding a number of matters, most notably the amount of outstanding debt. Other matters relate to vacancy inspections, the level of error and benefit related reliefs, and the outstanding valuation, the caseload. So members, I think it's important that we get a response from LPS to these points. So if we're agreed, we will write to LPS to get the response. People are content with that? 11.4 is relates to correspondence from an individual about the title of the correspondence is Removal of British Citizen from Northern Ireland. As members will know, the agreed approach to correspondence not linked to strategic priorities, which this isn't, is to advise correspondence to the relevant departments, which is best placed to deal with them. And I'm sure this is an important issue for the person in question, no doubt, but it's not for us to correspond with them. So if members are content, we will redirect them. Okay, members, we're now going to go and do the draft forward work programme, which is page 796. And the clerk will talk through a few bits.
So, Chair, just to update, members will recall we were looking to do a joint meeting with the Executive Office Committee around Public Sector Transformation Board. They haven't got into that yet. They obviously have a bill, as we have bills, so we're probably looking at maybe as late as spring next year before we can get a concurrent meeting organised where we both have a bit of breath around oral briefings for bills. We were due to have oral briefings around energy efficiency and building regs next week. However, those papers haven't got as far through the executive process as we would have expected at this stage, so they're asking if we can delay those if members are content. Also, the committee had agreed previously that the chair attend the meeting in Cardiff of the Interparliamentary Forum on Intergovernmental Relations at the end of November. Chair and Deputy Chair aren't able to go, so the attendance of the Assembly will be led by the Chair and Clerk of the Executive Office Committee instead. So just to inform members that's happening. And we've already got a members' agreement to reschedule and have Nathan's paper on Clause 18 next week. I think that's everything. Deputy Chair.
Okay, if we're agreed, then we'll show you.
Yeah, sorry, just on that, in terms of the Public Sector Transformation Board, the concern was raised given that it seems to have transferred to TEO and we still have an oversight role. I wonder that even though it's not until March that we would be having a joint meeting, can we ask TEO that we be kept in copy to correspondence around this until we've had, sort of thrashed this out a bit?
Yeah, that makes sense, yeah. Okay, so if members are content, we will publish the forward work programme on the committee website. Members are content. Item 13 is AOB, and the Deputy Chair, I believe, is an AOB.
Yeah, thank you. And I'd sought clarity following Chair's business with regard to the Economy Minister's written statements from the Chair of the Economy Committee. So just wanted to read into the record that the head of the Chair of the Economy Committee had already raised with the head of the Civil Service the concerns around the Minister for Economy's written statement with a number of matters raised, and the head of the Civil Service has replied thanking Mr Brett for his correspondence and advised that she's in the process of establishing the full factual position and will provide a substantive response as soon as she's in possession of all the relevant information necessary to address the issues raised in full. So it is under an investigation through different means.
Okay, that's fair enough. Thank you for that, and I think members will certainly want to see that and take a view on it. Further to our conversations earlier on, I think we've discussed those matters in detail. Okay, so if there's no other business at this stage, what I'm going to do is tell you the date, time and place of the next meeting, which is on Wednesday the 12th of November 2025 at 2 o'clock in the Senate chamber. And I'm now going to put the question to the committee to adjourn. The committee is now adjourned. Thank you all. I now need to run.